A very good morning, ladies and gentlemen, distinguished guests, members of Uganda Law Society joining us physically and those online, members of the bar and the bench, healthcare professionals, students, development partners, members of the media, and all our viewers joining us physically and those online. I greet you in the name of the Lord. We are very happy to receive you. And by the name Robert Benon Jurua, I am a legal officer in charge of litigation in the Rule of Law Department, coming for you live from Uganda Law Society, and it will be my singular honor to take you through this 18th edition of the Radical New Bar Live 2026 flagship weekly public and press engagement brought to you by the Radical New Bar of the Uganda Law Society under the Governing Council led by Isaac K. Semakade, the President, Senior Counsel. As always, this platform seeks to stimulate informed public discourse, bridge the gap between institutions and citizens, amplify professional voices, and foster meaningful partnerships that ultimately strengthen our country and its democratic institutions. Before we proceed, we would like to, on behalf of the Uganda Law Society and the Radical New Bar leadership, congratulate the new government that was sworn in recently, as well as the members of parliament who recently commenced their terms of office, and would like to pray that the Lord will guide them with wisdom for the next 5 years as we traverse through the aspects of democracy, governance, and leadership. Today, we are going to be discussing public service, which of course is a sacred trust, and we want to pray that we should have meaningful discussions as we are mandated to bring to you in regard to our mandate as the Uganda Law Society under Section 3, C and D to ensure we assist the government and the public in all matters touching and ancillary to the law. Our mandate compels us to engage on issues that deal with governance, justice, constitutionalism, accountability, access to justice, human rights, and public policy. We want, in a very special way, to thank the members that are here physically with us, but also those that are joining us online, because we are under a very critical time in which we are trying as much as possible to ensure access to justice, which of course is also coming in form of digital transformation. So you will bear with us to when we say that the majority of our audience is online with over 7,000 advocates, but also the public that is joining us online on various social media platforms, including but not limited to X, formerly Twitter, Zoom, and YouTube. We are very elated to receive you, and we pray that the Lord will guide us through this session so as to have meaningful discussions. Our program is going to flow as follows. We are going to begin the day with the national anthems, and thereafter we shall open the day with an opening prayer. Thereafter, we shall be listening in to the Chief Executive Officer in her remarks to the session in order also to lay the protocol of those that are here with us. And thereafter, we shall delve into the different sessions that we have to unpack that are going to be read out unto us, but also brought to our attention by the Chief Executive Officer. And thereafter, we shall obviously engage in a question and answer session, which is very much the crux of the discussion because it's a public and press engagement. We encourage all our members, both in the House and those that are joining us online, to easily place in a question, a comment, or whatever opinion you have, because this is a space of having these meaningful engagements. And thereafter, we shall be having a closure to the day. Would like to request you all to get on your feet so that we can sing the national anthems. Thank you so much.
ilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you so much. You can take your seats, please, as we welcome Miss Babirie Margaret for the opening prayer. Thank you.
Good morning, everyone. Let's pray. Almighty Father, we thank you for this day. We thank you for the gift of life. We thank you for the gift of Uganda Law Society. We thank you for the gift of other professional bodies, King of Glory. We thank you for these Rnblive sessions that we've been having over these years, King of Glory. We thank you for the leadership of Uganda Law Society, the council and the management, King of Glory. Thank you for the staff, Father Lord. Thank you, King of Glory, for the panelists of today, Father Lord. We pray, Father Lord, as they discuss on each topic, Father Lord, we pray that you fill them with the gift of wisdom, knowledge, and understanding, King of Glory. May there be impact on their voices, King of Glory. We pray that these voices move to a bigger audience, King of Glory, to the government, to every person who can work on the issues that people are coming to raise here, King of Glory. We pray, Father Lord, that you move every mountain in our lives, King of Glory. We pray, Father Lord, that your will may be done, King of Glory, and we ask you that your Holy Spirit may guide us this very day. We ask this through Christ our Lord. Amen.
Thank you so much, Maggie, for that very powerful prayer. Clearly, the Lord's presence is in this place, and I'm very excited about the prayer because we have prayed that the voices that are going to be tonight are going to impact the world, and we're very sure that what we have in stock for members is nothing less than ecstatic and very exciting. Would like to invite the head rule of law, Miss Afra Rapio, who is going to take the honor to read out unto us the remarks of the CEO, who is currently indisposed for matters that are equally important. Miss Afra Rapio, you're most welcome.
Thank you, Robert. Our distinguished guests today, Mr. Frank Asiimwe, Dr. Lutoti, Stephen, Mr. Frank Onyango, Mr. Dan Ramsey, Mr. Patrick Odongo, Dr. Ekwaru Obuku, Mr. Todi Galandi Kire, Mr. Ambrose Enen, the Governing Council of Uganda Law Society, our members of Uganda Law Society, members of the press, ladies and gentlemen, good morning. My name is Apio Afra. I'm the head rule of law, Uganda Law Society. I bring you warm greetings from the CEO, Ms. Christine Awori, who is unable to be with us this morning owing to an equally important engagement. My chief task this morning is to read her opening remarks verbatim, and I shall proceed to do so. On behalf of Uganda Law Society, I warmly welcome you to today's Rnblive weekly press and public engagement. Our first discussion focuses on the internship dilemma, unpacking the National Education and Training for Health Policy. Recent government policy changes have sparked widespread debate within Uganda's health sector. The new policy integrates medical internship into the academic training program and removes the government and removes the government allowances that medical interns have traditionally received. Critics, including medical professionals, students, and their representative bodies, have raised concerns about the financial burden on trainees, the impact on healthcare delivery, and the broader implications for the future of medical education and public health in Uganda. Our second topic is a fully paperless judiciary. Why aren't we ready? The judiciary has embarked on a digital transformation agenda, directing courts operating under the Electronic Court Case Management Information System, ECMIS, to transition to a fully paperless system. However, the transition also raises important questions. Are advocates, litigants, judicial officers, and court users adequately prepared? Do we have the necessary infrastructure, digital literacy, and connectivity to support such a transformation across the country? These are some of the issues we shall interrogate this morning. Our final discussion concerns the ULS statement on the Chief Justice Administrative Circular number 1 of 2026, and we shall be hearing from the ULS Council. We thank our guests for honoring our invitation. We also thank our participants who are here physically and those who are joining us via our online platforms such as Zoom, X, YouTube, and Facebook. We look forward to having a robust, insightful, and action-oriented discussion. I welcome you all once again. I thank you for your attention.
Thank you so much, Ms. Afra Rapio, for delivering those very strong remarks, but also very warming, because our mother, the CEO, who is always got our backs, never stops to receive us and bless us with these functions. We know you are quite engaged, but you always give it a few minutes to watch us every now and then. I see you all the time checking into us. We appreciate you, and we ask that the Lord will bless you in your endeavors. But also, thank you so much, Madam CEO, for the remarks, because they have set the pace, they have set the protocol, and we would like, of course, to begin it from there, because what you have raised and what you have spoken about is something that is very pressing and an issue that is affecting Uganda's future health workforce, especially the bill, or rather the policy that has easily been signed within the last few days, and of course was earlier on spoken about, like we shall be hearing from the panelists, and was never brought to effect until very recently. And our colleagues, or rather fellow professionals, are here to unpack what we don't know, what is being complained about. And we have evenly received concerns from Uganda Medical Association, Pharmaceutical Society of Uganda, Association of Intern Pharmacists Uganda, Association of Graduate Nurses and Midwives Uganda, medical students and intern doctors. There are very many issues that have been raised that are not very different from the predicament that very many professionals are facing. So it is in this way that the Uganda Law Society, under the leadership of the Governing Council and Isaac K. Semaka, the Senior Council, is taking a step forward and a gesture to evenly interact with different professionals. It is not a long time ago, like 1 month ago, we were hosting different professionals from the engineering fraternity, and this time around we're very, very honored to receive the medical fraternity. We have listened into what the CEO has said, but there is much more to listen into the individuals before us, and we're going to be listening into aspects like alleged inadequate stakeholder in consultation, concerns over internship remuneration, existing welfare challenges, training quality concerns, and transition mechanisms. And it obviously asks and begs a question: can we build a strong health system while weakening the welfare of the very professionals expected to sustain it? That is our trigger question, and we're going to take the opportunity to invite our first speaker, who is the board secretary of the Association of Graduate Nurses and Midwives of Uganda. We have with us, ladies and gentlemen, please welcome with me, Dan Muramuzi.
Thank you so much, the convener. Thank you, Uganda Law Society. Good morning, colleagues in the House. Good morning, colleagues online. My name is Dan Muramuzi, and I'm the board secretary, the Association of Graduate Nurses and Midwives of Uganda, and I step here to raise concerns. I stand here to raise concerns on the national education and training for health policy that has been passed by the government of Uganda through Ministry of Education and Ministry of Health. We agree that the ministry comes at a point, the policy comes at a point where a lot of concerns have been raised on the training and supervision of medical internship and the trainees or the interns during the medical internship period. However, if I treat the policy as a moving vehicle, we agree that some of the parts of the vehicle are faulty, and that means that the vehicle in its current form cannot move. The policy proposes a number of reforms in the supervision and training of medical interns during their one-year period. However, some of the proposals raised are still in question. For instance, the policy proposes that the interns who have been sponsored by government during their training period should be the only interns supported during internship period. However, that raises a question of segregation of this critical cadre that forms over 70% of the workforce during the hospital care, patient care and management, because this is not a training phase. This is a phase where people are supposed to acquire the critical competencies that may have been probably missed during the training. We know that most of our curricula are theory-based, and we have very few training institutions that have competence-based curricula as approved by National Council for Higher Education. So it is only during internship period that we get that opportunity to translate the theory into practice, to understand the context of their facilities, but also to prepare an intern into a fully fledged health professional who is going to deliver care to our Ugandans. There is another very critical component in the policy that we think must be addressed. During internship period, the expectation is that these interns work almost across 24 hours in different departments and units, and it calls for a person who is fully supported with a modest welfare, with modest housing, modest lunch, modest other few amenities to ensure that they keep moving as a vehicle. But if the Ministry of Education and Sports and Ministry of Health proposes to scrap off the allowance, which is not really a salary, but an allowance which you want someone to keep moving as they provide the critical care, we think this is a very, very dangerous position in the current policy. The policy, again, in terms of nursing training and education, proposes some ratios that we think are not in current form, in the current staffing level of most of the facilities, which is actually less than 40% staffing capacity of most of our hospitals. The policy proposes educators or supervisors within our health workforce, which of course they are not there currently. We don't have nurse educators within our health facilities. That would call a further recruitment of this critical cadre, which has not been planned for in the policy. We don't have these specialist nurses and consultants even at general hospitals, that's the district hospitals, which the policy proposes that these people should supervise interns. So it is very, very critical that the policy in current form cannot be implemented effectively unless we just maintain it as a wish list within the document. The third point, in the interest of time, is the issue of, let me check here. The issue of the development of the policy. Yes, the policy development undergoes various stages, from initial conceptualization into the stakeholder engagement, into stakeholder consultations with key primary and secondary stakeholders. And in this case, the healthcare workforce, the healthcare professional associations form part of the primary key stakeholders. In our argument across board, we did not get such consultation, and our views in the current policy are not captured, and yet we are the end user of the policy. So we propose that the policy in its current form can be retracted, and we have further stakeholder engagement to ensure that we address the key issues that form our healthcare system. For now, I would step down to allow our colleagues to add on my voice. Thank you.
Thank you so much, Dan. That was very summarized, but also because, you know, doctors don't speak a lot. Doctors are more interested in how you're doing as far as your body temperature is concerned, and things like the critical care and critical training that interns go through, and you raise very critical issues that cannot go without bringing to the fore. And it's very important for us to remind our viewers and listeners in there that there is a policy that was recently, as we say, passed and effected, which of course is affecting the intern students, but also indirectly affects the doctors or their supervisors, but as well very much affects the general public, because these are a very core and critical part in the healthcare system, especially given that we know it has been awash the media about how these students have been treated and the complaints and concerns that they have been having over time. And of course, it goes without saying that they need to be raised. We want to thank you so much, the board secretary, for opening the floor and setting the pace. And of course, we're going to have a lot more of these conversations. All we request is for you to keep it locked and also pay attention and raise in your question, because there just might not be everything said by these individuals, especially knowing that we are speaking to the whole nation and the whole country. Therefore, there is bound to be different opinions from different people. We would like to move it very fast. After we've heard from Dan, there is the vice president who is supposed to be joining us online, graduate nurses and midwives of Uganda. I want to find out from my IT if he is available, and if he is, you would kindly unmute him so that we can hear from him and see if he can share with us his remarks before we get to the next panelists who are in the building. We, as we said, are very much alive to digital transformation, so you will kindly bear with us because some of the members that are going to be speaking to us are coming to us online. Mr. Patrick Odongo, are you available? Can you hear us, please? We can't hear you, whereas we see you saying something. Are you able to hear us?
I do pick you very loud and clear. I wonder if you can now be in a position to hear me too.
Loud and clear, sir. We can hear you. Please proceed. You're being listened to and also watched online.
All right. Thank you very much, Uganda Law Society, through your radical new bar, for organizing this very important engagement across the different associations, the different bodies that are involved in this current policy. And also, I want to acknowledge the previous speaker, who is my board secretary. I want to applaud him for the points that he has put forward. And to now go back to the current topic of discussion, I think the reason I was not in a position to be present in the audience right now is so some and there. Very, very clear. For sure, acknowledge that a policy as this one is quite, and it should definitely. We think that this in particular is meant to direct, guide, train, education and training of house workforce, especially those who are aspiring as young professionals joining today or tomorrow the entire workforce. So, given the background so far that has been shared by the previous speaker, I want to agree with him to a larger extent that this policy in its current formulation does not serve the purpose. Because the dictates within this policy from our different point of views looks at mainly protecting and keeping the interest of one main player, and that is government. We do know that policies are supposed to be discussed and shaped by different opinions. But in this case, and for this reason, I want to be clear that this was crafted without consultation, thorough consultation of the different stakeholders that matter when it comes to healthcare. I must say that this is not the first time that a policy such as this one is crafted in boardrooms and then championed by our fellow health professionals who are in leadership, who are in administration, to push it to the high of the people who are supposed to be directly involved and who are supposed to contribute immensely in the process of its development. Shortly, just to bring you also another background, we've had a policy of internship waiver that it's still currently being, it's currently under review. We've gone through the normal challenging it through dialogues, through meetings, through even legal strategies, but up to now, it has not yet been resolved amicably. We are still waiting for court to pronounce itself on whether there should be waiver of internship for a certain cadre of nursing and midwifery. We know that they've gone through training. They've also had some previous experiences. These are people who have come through system of upgrading to get a degree. And so they all have reached a point where they all need to be harmonized, unified, and put on the same scale. And here we see a policy that is trying to exempt them from gaining internship experience, which is a competence-based training. So that we challenge it, and we believe that it should not happen in this country, because we nurses and midwives are prepared to not only operate locally in the country, but we are supposed to fit ourselves regionally and also at international level. So we see this as a gap. So if looking at this current policy, I completely see in the fraternity of nursing and midwifery believe that this was mainly designed to favor government, and actually they're looking at saving costs, but in the long run this does not exactly come to that. If you have a struggling healthcare system like we are now, and we begin to eliminate, because this is direct elimination of those who are unable to afford. I must tell you that by the end of 4th year, 5th year, a medical student has reached a point of exhaustion. The whole mindset is all about endeavor to complete that additional 1 year of skilling and improving the competence to go out ready to serve. But in this merge, trade, university, and then adding on to internship, which is completely a new phase of a new dimension and a new phase of trade. In one, I think this completely failed to meet the standard. What we have completed literally every part of their training, and this time, this 1 year is just given to them to really become more independent when they get out. But also it's a mandatory requirement by standards of law that this 1 year be accomplished, because it is the only ticket that gives you a leeway to go out and be licensed to practice after you qualify. So I see a big gap created by our own people. This vacuum created by real medical professionals. For instance, we know that Ministry of Health is indeed commanded by a well-trained medical personnel who is in the position of a minister, who is believed and all issues around healthcare. This is the right person who should give to government. I completely see this person in the mix. And I can also see that this person, these people are just trying to protect something. I must make it clear that there is no protection of your position. If you are there, you are there on merit. You are there on ticket, and you are there to represent the profession, so that something is not out of hand, out of control like we currently have. This is a very, very important issue, and I want to thank the people who have organized this. So in my argument, number one is that this policy in the current state is not well grounded, that it has not involved different people to participate and give input at the early phase. So therefore it misses it loses them the position for which it was supposed to address. I also want to mention that this policy is not fair, and it is also going to introduce inequities in opportunities in terms of training. We are now going to end up with a group of people who managed to go through the training from the university, did successfully, but are now they are now currently blocked from going all the way to become that professional that they desired to be, because they will not be in a position, many and not few, will not be in a position to afford the cost of putting your own transport, providing for your own meals and your accommodation. That kind of money is actually not going to be afforded by all, except a few. Maybe even the ones who will afford are people who are from a certain class. So this potentially, in my view, will introduce inequity in health care profession, and we need to stop this without delay. Third, I want to also mention that this policy, the way it is, if we allow it to be, it will potentially cause human harm. In our principles of ethics, medical ethics, the goal of medical training and the profession is to actually ensure that it brings out the component of beneficence and no harm, doing no harm. But I see that by government shifting to blockade the interns from undertaking internship training through denying them stipends, it means that we shall create a very big gap that will not be addressed in the shortest possible time. By doing so, our hospitals, from what we know, is that these interns are the ones, they are the face of the hospital. The hospitals are mainly, seem to be doing to be guiding, to be providing administrative figure, but the actual answer really remains in the hands of these mighty interns. I call them mighty because all of us, including the ministers that are now championing this policy, have also gone through this similar experience. So I want to imagine.
Mr. Dongo, kindly conclude, please.
This policy is upheld the way it is. Okay, be in a position to undertake internship and complete. To be a human that cannot be filled by currency. That the patients are going to come to the hospital. They will not be attended to. There will be delays in the procedures that are lifesavers, and there is going to be a nurse who is going to go hungry, and they are not in a position to respond to emergencies that they deal with on a daily. So in this way, these patients potentially are going to be harmed, where some of them may end up with complications, die from it. So I believe that this policy should be revised, should be pushed back, and new discussion should be there so that it is improved, it is and it is brought in a context that it is really solving problems but not getting more problems. Thank you very much.
Thank you so much, Mr. Dongo, for the very, very elaborate discussion that you've helped us to appreciate and underscore. You have easily appreciated that the narrative is the same. You are actually agreeing to a very large extent, larger than you had said, because we've had almost the same things. But of course, from a different tone and from a different capacity. As you have raised it, you are clearly showing us that the interests served in the policy serve only the government, and yet the primary stakeholders are not in the know, neither are they consulted in regard to what it takes to get different opinions. You're actually asking that the government should accept that there is always room for different opinions so as to come up with a document that serves all. But of course, what you have easily told us is that the policy is not well grounded, and it's going to have critical effects if not improved for the benefit of the intern students, especially when you identify with the fact that the students are across the country, and we can all bear that witness, because if you've visited the different government departments, rather facilities, health facilities in the different districts of the country, you're most likely going to find internship students, beginning with the emergency, that's the casualty ward, where lives are very critical, but also you find them in bigger departments in the different hospitals. So for you to say that without this internship remuneration or better welfare, we are putting the lives of the general public into question. Thank you so much once again. You said you couldn't join us physically. We have easily listened out into you, and we thank you for everything that you've shared, and pray that God will bless you as you continue to do your endeavors wherever you are. Ladies and gentlemen, we want to thank you so much for the time. We know there is quite a number of speakers in the building, and we're going to kindly request that whenever we give you the microphone or we yield the floor to you, you will at least do the best to keep time and have everybody speak, so that we can hear the perspective of the different bodies. As we said, we are hosting different bodies from the medical fraternity, and it is important that each body speaks out in order to allow that the other members who are not here, or the leaders, will be satisfied that their concerns have been brought to the fore. Right about now, we would like to move forth to the next speaker, and in the building with us, ladies and gentlemen, we have the president of the Association of Intern Pharmacists of Uganda, who also is an intern pharmacist at Entebbe Regional Referral Hospital, and we are actually speaking about one who is in the thicket of the implementation of the policy, and there's none other than a person before us who is also the president of the intern pharmacists in Uganda. Ladies and gentlemen, please welcome with me Mr. Onyango Frank.
All right. Thank you so much. As they have introduced to me, I am Onyango Frank, and I'm currently an intern. So when I'm speaking, at least I have a fresh mind of what interns go through. All protocol observed, I would like to thank the previous speakers, and I would also like to add on a voice on what they have said. We learned about this policy from the press, but we also later got it, and we had a chance to read it through. However, you know, it is good to have the policy. Wouldn't be bad. It's good to have a policy. There's need to regulate the education in the country. However, there are some few issues that were missed in the policy. You know, when I was reading through the objective, one of the objectives of the policy was to improve the quality and the quantity of training of health professionals in Uganda. But there is no way you can say that you are improving the quality of education when you are depriving of majorly the financial bit of it. Like currently, if you look at interns, I'm speaking on behalf of all interns, both all the nurses, the pharmacists, and the medical interns, my fellow GHOs. The interns are the front line runners of these facilities. Like they work, some of us work 36 hours. I came in late today because I was just attending to something. I was receiving a consignment of Ebola before I had to come in. So you cannot work 36 hours and you go without financial support. And also providing for only government-sponsored students. Actually, this one is going to create a bigger gap. What should the private sponsored students do? And what should, we have colleagues who were sponsored by different organizations, and their sponsorship only stops at training. What will they do? They come from humble backgrounds where families cannot afford to facilitate them. Actually, I find the policy somehow lacking. For us, as interns, we are about to complete, but the interns that are coming, our prayer would be they reinstate this financial funding. Besides, this is a policy which has been formed. It has found the interns, some of the colleagues are already at completion. There are those who have already graduated and are just waiting for deployment. The policy says interns there shall be no graduation without completion of the institutions. Here, it also creates some financial burden. How? We shall have students, in quotes, being regarded as interns. Where will they belong? Will they be at the university or they will be interns? If they're at university, then are they going to pay tuition for the last year? Automatically, for private institutions, they are most likely to accept, and they say, fine, since you're still our student, continue paying tuition. Now, we have some of the students still, as I have said, who are being sponsored. They have already entered contractual terms with the sponsors, and the sponsors are to sponsor them only 5 years, and here they are adding them 6 years. Most likely they are bound not to complete the course. And actually it will increase further financial burden. It is also going to create loss of morale among the interns. Just imagine they have called you upon, okay, I look at interns as soldiers who are in training. Like we have a war, there are soldiers who are in training, they are not being paid, then they tell them to go on front line. Do you think they are going to fight for the country? They are most likely to turn into rebels. And at the end of the day, government may not achieve. And actually, the population also may not get the right health care services that they are getting right now. If you look at, okay, fine, if we say graduation after completion, not every person who enrolls to medical school wants to go and practice. There are those who just want to get the degree and they go away. So how are those ones going to be handled? We have international students who are studying from Uganda. They are not going to practice in Uganda. Will you also tie internship on them that they move out of the country after internship? And if yes, are you going to register them here as interns? And for the interns of this country who are Ugandan citizens, you know, as an intern, we are legally protected. Why? We have provisional licensure from our mother bodies. The nurses from Nursing Council, the pharmacists from Pharmaceutical Society of Uganda, the GHOs from Uganda Medical and Dental Practitioners Council. Now, who is going to provide that provisional license, and are they going to provide it to the students? And if, say, it is the respective bodies, how is the transition going to happen? And in case you don't give to me that legal document, I mean that provisional license, and anything happens, how are interns going to be protected legally? Because right now, in case of anything, I'm sure Dr. Tot is here, I will run to him and I will be protected. Lastly, we have always had delays in deployment of interns, and their major excuse was, one, we lack experts, consultants to supervise the interns. Then also they said they lack there's lack of budget. But however, the big man said there is budget. There are 2.5 million shillings for each intern. For you, your father has said there is money, but the maid is saying, no, there is no money, go hungry. Surely, what should we follow? Should we go with what the other one says, or we go with what the maid says? There's no time. Our former Minister of Finance, there's no time. Whenever they ask him, we say, money, colleagues, money is there. So there is money. Maybe they don't know how to ask for it. If they don't know, let them engage us. We can tell them. We have better mechanisms of asking for money. We can easily engage. Thank you so much. With those few remarks, I beg to stop here.
Colleagues, money is there or it will come. Now we don't know which one to take. And he's no longer the Minister for Finance. We don't know. Thank you so much, Mr. Nyango. You have ably brought it out to the fore. And I know there are some one or two facilitators of yours, lecturers. I see you receiving, you washing your hands, because these are medical personnel. They moved with their small spray. You received Ebola. Thank you so much. As a student and as a president at the same time, you have ably done justice to the topic, because, of course, now we have a little more senior colleagues of yours here who I know you have either gone through as a student, because these are lecturers in different institutions, and we would like to thank you for bringing to the fore, especially when you identify the intern students as soldiers in the training, and you know what it means. I'm not one, of course, and I don't know if there's any here, but we don't have to ask so much about what it means to have facilitation when you're undergoing intense training for which there is no room for error, because the error is going to cause death to somebody, as an innocent citizen, and that is going to have a very big impact on the families of these patients. So that is how critical our intern students are, in as much as they haven't necessarily reached the level of, as we have found, doctors and pharmacists, but they are not any different except for experience, and the experience is only gotten under the supervision of these very able leaders we have. And it means you cannot deprive a soldier who is in the bush, because remember, he's also holding a gun. This Mr. Nyango is imagining they can easily become rebels. I mean, he has a syringe, he has some overdose of maybe quinine or chloroquine or whatever it is. In his frustration, before you know it, you become a victim. So that is how important the discussion is, and we have easily been joined by different bodies in the healthcare fraternity, because this is a very hot topic, ladies and gentlemen, and we really request that you keep your ears to the ground, because a lot is being unfolded. It might be the same topic, but there are various opinions and concerns. Now, Onyango is saying they have better mechanisms of asking the finance ministry for money. You know what they do? They lay their tools down. That is also another option, so that the government can call you, because it cannot be taken for granted. In as much as I'm leaving my place of abode from whatever place, Matuga, moving to Mulago, it's going to be some amount of money. I'm leaving a family behind. There's a lot to be concerned about than ask me to cater to a patient who is complaining and is actually needing very critical care. That is how much and risky it is. It will cost for us not to address these issues. And like we said, as the Uganda Law Society, we're here to listen to your concerns. You looked for a lawyer, say no more. Where you are, plot 5A, Acacia Avenue, is exactly where you're going to get this support. We would like very fast to welcome another speaker who actually belongs, to whom the Onyango, the precurrent speaker, belongs, and that is the Federation for Uganda Medical Interns. I would like to welcome Dr. Jacob Mwada. Thank you.
Thank you so much, moderator. Thank you so much, Uganda Law Society, for this. It's been long overdue. Since interns saw non-medical workers who care about them. Thank you so much. And we shall always remain indebted and grateful for these opportunities. As I've been introduced, I'm Dr. Jacob Mwanda, the president of Federation for Uganda Medical Interns in this country, 2025-2026. To start with, I would like to tell you that there is no student in the category of people I lead. Everyone is a graduate with fully awarded degrees, fully qualified, and out to serve the nation. Where we work, it's 50-50. If the supervisor is there and there's something challenging, that day you learn something, of which 70% of the times I'm in the mix alone. The reason as to why people are concerned is because we offer more than 70% of Uganda's healthcare services. Government itself has failed to fill in the positions of these people who are supposed to be in these hospitals. That's why health workers are now languishing on streets, and the work is being covered by interns. We insist and tell everyone we cannot offer services for free. Because at the end of the day, I need energy. Energy which is provided by carbohydrates which come from food, which I have to eat. When I have not eaten, how do you expect me to stand and operate the mother? When a doctor collapses in a theater, who cares? It is your father and mother who are going to bury. This patient will have another one substituted and will be operated. So these are things that we are saying, no. Government, look, we can work as we have been working, but please make sure you facilitate this working. And without the facilitation, there shall be no work. I would like to interest the Uganda Law Society into a few things. You know, we have been there suffering and we don't have time to chase up some of these things. But I would like you to interest yourselves in one, curriculum coverages for medical workers. What is being suggested against the current curriculums, because the curriculum says all admissions actually, every student who joins the medical course is under curriculum which says within these 5 years, you will complete this course and you will be awarded. For example, I was awarded a degree of bachelor's in medicine and bachelor's in surgery after 5.5 years. That's what I signed for. And after those 5 years, my degree was given unto me. What to do after that is entirely upon me, because it is me who knows why I started this course. Now, for you to say that, even though I signed with the university 5-year agreement, when I have finished my university things, I should not be given my degree. Why? Why shouldn't somebody get such a degree? Why? Why didn't you tell this person before he started the course that after the 5 years, you will not get that degree until you do mandatory internship? All this is being done because they want to label interns as students. Interns are not students. You can't take me back to my university. I finished university business completely. I have my degree. Whatever I do with my degree depends upon me. Because I want to practice medicine, I'm doing internship. I have colleagues who left the country and went to Kenya. I have colleagues who went to USA. We wrote the final exam together. We graduated together. They have left the country. Now, how do you start subjecting people who have finished the degrees to stay under the university? And be supervised by who? Universities have employees whom they pay to teach their students. Now you are telling interns who have finished that you will send them under the universities to do what? That is one. Two, you are saying universities are producing incompetent interns. That is the label. I think we have all heard that they are incompetent. But you are again subjecting now the same incompetent trainers to train even the internship, which you would have used to polish the incompetence that the universities have sent. And this is why we are saying this policy is wrong. We have been advocates with my brother, the president of WUMA, for an internship policy. Why have we wanted an internship policy? We want this policy to be known that an intern is supposed to earn this amount of shillings per month. An intern is supposed to work these specific hours a day. As we talk, we work 24 hours a day. And your supervisor does not care. Whether you went back to home or to freshen up or you have not eaten, they don't really care. These are things we're advocating for that should stop. Unfortunately, the policy doesn't cover such things. We were saying, if an intern falls sick, the policy should be catering who should treat the intern. Because I am from Kabale, you have sent me to Arua, I reach Arua and I fall sick. The hospital tells you, this is a common business for everyone knows it. That you reach there is no Panadol, there is no Septrin, there is no common medicine. And you're telling an intern whom you pay after 4 months that, look, bro, you have to buy a test of 50K per dose. Because according to your weight, that is what is enough. So, we are like, this guy has spent 4 months, has not yet earned money. How do you expect the guy to be treated? So these are things we're advocating for to be in the internship policy. So, let me not speak a lot. I would like to interest the Uganda Law Society into the following things. One, change of curriculum for Uganda graduate nurses. Every graduate nurse is supposed to do internship as per the curriculum in this country. We have a category who were unfairly denied internship, and here there is a rumor that they want to make them do an exam to give them licenses, which is very wrong. And the people who are forcing these things to happen are in this country. Unfortunately, they are health workers. Please interest yourself in that. No one should be maliced, because at the end of the day, you will land in the hands of this nurse who is incompetent. Two, we have breach of contracts. Personally signed a contract with the Ministry of Health, which was a 1-year contract, and I'm supposed to get an allowance of 1 million per month. Ministry of Health has never given me a coin. Asserting because I'm an employee of government, I'm here on leave to upgrade, that I use salary from the other job, which is in the loans. Sure, which is in loans, has to take care of the family that I left behind. You know, when you are home, you can easily dig potatoes and give children to eat. But when you are far, you have to buy rice, because you can't tell the maid to go to the garden. It is hard. If she goes today, tomorrow she will not go. And if you don't send the rice, then your children will go hungry. And second, the children have school fees to pay. All that is for the salary. Then you expect me to come here, work from morning up to another morning, then up to evening, on free. We have those licenses. We even went to court, but court is not helping us. It's not helping us. And this time round, we have been very considerate not to put down tools, because the people who died are innocent. These people don't come to these hospitals. They make the policies up there, but they don't come. So that's why we are being reluctant, though our patience is being tested. Then we also have very many trivial interns allowances being taken. I don't know by who. Somebody gets a small misunderstanding, allowances for the next 7 months don't come. You should really, guys, may have information for you. I will give you this information. We need to put these people to accountability. Where does this money go? As I talk with her, over 50 interns. Since January, guys are not earning. So that is another one. Then about the policy, people who develop this policy, we should surely agree that the ethics of policy development were not followed. So through Uganda Law Society, we want to make these people accountable. let these people refund all the money they took that they are making consultations. Because consultations were not made. I'm the president of Uganda Federation for Uganda Medical Interns. I was not consulted. My predecessor, I was talking with him and I have a full file. He was not consulted. And so is the previous one beyond him. No consultations were made. But I know somewhere there must be documents showing that we were consulted. Please, let us take on this, and these people should refund government resources. I would also like to interest you that we should prepare and take the universities to court that will prepare to break the contracts they signed with their customers. Because every university signed when they are conscious and sober that after the 5 years, they will award these students their degrees. This business of saying that the university will retain you for 1 extra year when you have fulfilled everything it asked for, please prepare and help us. We take them to court. I'm requesting for you because for us we have gone to court genuinely, and court pretends as if we have not gone there. But since you're the custodians inside there, maybe you know what to do to make courts listen to us. I want to end by really stating that this policy is unfair, undue, inconsiderate, and unpatriotic. And also finally unethical, because I cannot stay under university and then I'm registered by Uganda Medical and Dental Practitioners Council when I'm still under my academic registrar. Then the UMDPC gives me a provisional practicing license when I'm still a student. Then the Ministry of Health distributes me to do internship when I'm still a student. And then ever after internship, I go back to my academic registrar to give me a degree. The question is, what is UMDPC licensing? If it wants to license a 5th-year student who has no license, it is equivalent, who has no degree, it is equivalent to licensing a 4th year. It is equivalent to licensing a 3rd year. And those are things they can tell you. If we allow this policy to pass the way it is, to be implemented the way it is, that is what is going to happen. I have my son, I have the influence. My son is in the 3rd year, but I want him to finish. I will influence, they will deploy him. He will get a degree after 3 years. I'm telling you the truth. This is Uganda. This is Uganda. Because as I talk, I know people who don't have the degrees but are doing internship. Their classmates are going to start internship now. But as I talk, they are finishing internship. Where did they pass? What did they take to UMDPC? Nothing. They can't convince us that they took there anything. So if we don't look into this now and we help each other, I can assure you at the end of the day, it is my relative, of which mine is unlikely because I will treat him myself, but your relative might land into the hands of these people. So please, thank you so much, Uganda Law Society. How I wish all other bodies take up this and we help each other. Thank you so much.
Thank you so much, Dr. Jacob. You have used the words unfair, unethical, and unpatriotic to describe a policy that is meant to help the people that you are representing, and that leaves a lot to be desired. You have also brought forth some very critical aspects, including 70% of the work that is being done by these interns, which of course informs us in as far as how much we are at stake, our lives at stake. If we don't care about this 70%, then it means the majority of the population in Uganda is also at stake. And of course, you have talked about curriculum coverages for medical workers and the misrepresentation to the public, as well as the finished university contracts that have not been honored. And you have easily spoken into the aspects you want to help have addressed. You have given a clarion call to the Uganda Law Society, and maybe for your information, whenever you speak Uganda Law Society now, you add the radical new bar, which is here to bang tables. And it is our role as the Uganda Law Society, under the very able leadership of the President, Isaac K. Semakade Senior Counsel, who is easily watching us as we talk, just know that your concerns are being registered, and he has a very, very serious follower on this same table who is going to come and speak to us, and we are going to ensure that we shall do the best within our means to make sure your concerns are brought to book, because as you said, it is our role as especially the rule of law department, but also under the governing council of the Radical New Bar, to ensure that the public is satisfied in as far as achieving the goals for rule of law are concerned. Equality before the law. If you have taken a case to court and you have not had any audience, not because you're not a lawyer, actually in any case, because you're not a lawyer, you need to be getting the treatment better, because it will mean that our bedroom is not in order. If a foreigner can come into our building and find that the place is not clean, that leaves a speck in our eyes. So we are going to ensure that the mindset of the doctors is much changed, especially given the Radical New Bar is in charge of this governance issue. We would like to thank you so much. And of course, we would like to make a very categorical apology to the members that are joining us online, but also to you, the individuals here. I have continually and have received comments online. We want to thank you for the comments that are coming. We receive positive criticism. I have been found in error to identify the intern students as students. They are not students. I've been told. Mr. Watua, oh yes, we have Watua Philip. He's giving us a very good comment. Even those who think they can afford private health care don't know when and where an emergency like accidents will occur, unto in most times when this occurs, you will be in the hands of these demotivated interns. That's a very critical aspect that has been raised. We have a comment here from Lufafa Godwin. Please receive our apologies. We're here to learn and do not have us in the wrong side of your mind. You're saying we are not students. Another has said, the moderator is continuously using intern students and it's annoying. We don't want to annoy you. We're here to learn. We want to apologize categorically. In our world of the legal fraternity, interns here are students. Let us set the record straight. When they're in year 3, they come to such organizations for internship. So in our mind, we had seen them as students, but it's also okay to be corrected. Thank you so much for the correction. We shall continue to accord you the respect that you have earned, especially after Dr. Jacob described that they are not any more students. They are all graduates with degrees. Is that right? So from now on, tuko pamoja. Is that okay? Thank you so much. Yes, we would like to move forth very fast into the next speaker, listening to the next speaker, and of course, it is still the same aspect and a different position. And right about now, we want to listen to the president of Pharmaceutical Society Uganda. That is Dr. Stephen Lutoti. You're very welcome to the podium, sir.
So colleagues, I'm Dr. Stephen Lutoti, the Secretary of the Pharmaceutical Society of Uganda. And Pharmaceutical Society of Uganda is a professional body for pharmacists in Uganda. We are the experts in drugs, and drugs can be medicines or poisons, depending on the way you handle them. And therefore, we expect that right people handle medicines with people who can correctly make diagnosis, and then right prescriptions are made, and then proper dispensing of these medicines, the administration is done, and then monitoring of the patient. And managing a patient is teamwork. So that's why you see all of us here working together to ensure that the patient interests are catered for. On this policy, to to give you a highlight, because this is the document we are talking about, okay? So some of you may just be hearing, but this is what we are talking about. One, it may be deliberate to make it this thick so that you don't even have time to to peruse through it. But what is contained here, this is 317 pages of this document, a compilation of a policy which was made in 2025. The policy is National Education and Training for Health Policy. So it was made in 2025. But the challenge is that it is just recent. Within here, they also developed implementation standards. So these implementation standards were now developed in 2026. So we had a policy last year developed quietly without adequate stakeholder consultations, so that these views we are airing here could be catered for. And we have the standards, and then we have the implementation guidelines. So the document is having these three. So the implementation standards are of 2026. The implementation guidelines were also developed in 2026. According to what we see in the document, despite developing the policy in 2025, the implementation standards were signed on 26th of February 2026. Get it? So we are just, and now because internship runs for 12 months, and interns, they do internship from August to July. You and I know that this is June, meaning that July, the cohort of the colleagues, interns who have just spoken to you, they are going to leave the facilities. So this policy does not clearly specify the implementation dates. I think it was again deliberate, so that you propose something, but you don't clearly indicate when you want to put it there. So despite the challenges which are there, you keep on, you show as if you are going to continue doing the same thing, but all of a sudden you put it out because you are overwhelmed by what is there. So both the implementation standards and the implementation guidelines were signed on 26 February 2026. So the guidelines, the standards signed here by the First Lady and the Minister of Education and Sports, and also the Minister of Health. Then we have the guidelines, the signing and issuance of the approval and adoption of these guidelines were again also signed on the same day, 26th February 2026, by Dr. Kedres R. to the agenda, who is the Permanent Secretary, Minister of Education and Sports, Dr. Diana Atwine, the Permanent Secretary, Minister of Health, and these were acknowledged by officials in the Ministry of Health. That is Dr. Safina K. Musene, the Commissioner Health, Education and Training, Ministry of Education and Sports, and then Dr. Ronnie Bahatunjire, Commissioner Clinical Services, Ministry of Health. So ladies and gentlemen, these are the brains behind this policy sanctioning what should be done as far as this policy is concerned. May not have read this, but what are our concerns? Our concern is, first, not to be misunderstood, is that we as Pharmaceutical Society of Uganda, we reject the policy in regard to internship especially. We reject it, and we say the implementation must be suspended. One, for lack of adequate consultations, okay? 2, that the policy offends the doctrine of legitimate expectation, okay? So you cannot say that people should graduate after university, because that is not the contract they entered in with the university. If there is any proposal in that line, then we can discuss it, and it will only apply to those who are yet to join the university, because it calls for curriculum review, and once you review the curricula, you don't implement that curriculum on those who are still at the university in that year. You implement it on those who are coming. Okay? So, we say no. The Pharmaceutical Society of Uganda vehemently says no implementation of this policy in regard to internship proposals which are there until we have had another opportunity to sit down and discuss and see how possible to implement this framework. It is in good faith, and this is the real patriotism we are talking about. Okay? Our concern is this policy has 7 policy objectives, and these objectives take note of different aspects which are very good. So our only concern here, why we're actually discussing, is on the last objective. We are having the objective on internship. So particularly, just for us to be on the same page, so that as we maybe deliberate some of these things, is when you refer to the policy, you may not have opportunity to read up the entire policy as such, but when you refer to the policy, these are the policy objectives. 1, to attain adequate quality and quantity of health trainees. We in this room, we say it is okay. Okay? We don't have a challenge with this. Policy objective 2, to increase enrollment of specialized health trainees. That is a tick. We say it is okay. We want more specialized health trainees. That's okay. To improve the quality of health training facilities. That is fine, because our training facilities are having challenges. Policy objective number 5 is where we raise some concern. To strengthen internship, rotation, and clinical practice. That is policy objective number 5, section 7.5 on page 29 of the policy. And how we find the disconnect is that whereas the policy is intended to develop and implement a plan to improve the welfare for medical interns, we then ask ourselves, in medical school we learn about sleep, how sleep goes, the time when you dream, it is in phases, okay? So this policy at some point, as if it is for us, and then in another section, you find, so it says the person in REM sleep, there is a phase called REM, rapid eye movement. So you'll be there, you're dreaming. Yeah? So we say the person wake up and then realize something else. Why do we say so? We go back to the background information. The background recognizes the global context, the region, what is happening, and it is very rosy as far as the global picture is concerned. The region is concerned. Interns in Kenya, Tanzania, Rwanda, where the picture is different. Now, we come to the national context. They try to show something. When you check page 15 of the policy, 14-15, it talks about gaps in human resources for health. They even provide a table. Of course, they don't indicate as well for pharmacy. I don't know, for whatever reason. But for record purposes, in Uganda, we have 2,216 pharmacists. registered, okay? And we, in the population, can see we expect 1 to 1,000. So it means one is serving 20,300 Ugandans. So we expect that the ratios, of course, definitely indicate we have gaps. We have gaps which are recognized there, which is contrary to the narrative we are hearing that we have more human resources for health in the country. It is a global challenge. We don't have enough human resource for health. You get it? Yeah? So it is a privilege for health workers who choose to stay here in Uganda and serve Ugandans. Because elsewhere, they are also looking for health professionals to go there. And in this policy, where we see the disconnect is, we say, if we look at the background information and you look at the situation in the situational analysis on page 17 is in respect to internship. Look at what they are saying to assess our current situation vis-a-vis what they are proposing. The document speaks for itself. It is stated that eligible students in health education and training programs are expected to undergo internship for a specific period under supervision in accredited health center. The issue of concern is that there is inadequate and insufficient training for health profession students during the internship. We say, as has always, you were corrected as well, interns are not students. Medical interns are not students. Okay? Now, they indicate that the inadequate and insufficient internship, even as we are doing in terms of internship, is caused by lack of a well-structured internship program brought about by what? Unclear roles of multiple stakeholders involved in training and implementation of the internship program, lack of compliance to the set standards by the health training institutions, inadequate number and capacity of supervisors. We don't have enough what? Supervisors. Already. 2, inadequate number of internship training centers. We have few training centers. Inadequate tools and equipment. Those who are already qualified and practicing already are struggling to use what is there. Shortage of drugs, shortage of these supplies, shortage of this and that. But I mean, is that still they are serving. Poor welfare. You see what they recognize. As I said, the person, the team, with due respect, without prejudice. Poor welfare for the interns and the supervisors, and the ever-increasing number of interns that was affecting the quality. They recognize that the welfare, the poor welfare of interns has been affecting the quality of interns. Yet, we see what they prescribe. They clearly indicate there's limitation in funding for new positions that we have. But even the existing positions, we have gaps where the positions in the structure, public health structure, are not filled. Get it? You will be lucky to go to a hospital and even find a registered pharmacist in that hospital. Go to your home district and check your health facility and see whether there is a pharmacist in that setting. Get it? So already, even if we have structures that allow people to go there, the people are not recruited in those settings. At the same time, new positions expect to be created, but still there is no position. So this is the situation that we are in. So I encourage you, just peruse page 17. It gives you a clear picture of the situation as far as internship and training issues are concerned. So we note that there is a deficit of health workers, which is also acknowledged. That's why I say the person dreaming, or those who are speaking for this policy, either they have not read what was written. Because I invite you to paragraph 29, page 16 of this policy. It is clearly indicated that the country needs more than 50 training institutions offering specialized programs. As listed, they put a table. This implies building more training institutions, rehabilitating and equipping the old ones to offer quality health education. We have few training institutions. 2, currently, there are high numbers of students on some programs in 2001 tertiary institutions and 18. However, to meet our health education and training needs, they are acknowledging the health the gap. The country requires over 250 additional health training institutions distributed across the country to absorb how many? About 180 students per year. They are already saying that we need more training institutions. At the same time, someone is saying we have more. The workers who are there. We have the universities have already admitted more wishing there. So what exactly do we want? What is the actual situation? Is the person in REM phase of sleep or is in another phase? We don't know what is happening here. So when we analyze the situation, there is a disconnect. It is acknowledging deficit in health workforce and recommending us to have more health training institutions, have more internship centers, but at the same time, the policymakers are crying and they are saying that we have very many health workers around. We are overwhelmed. So what is the situation? Now, to cure the problem, you must understand what exactly is the problem. Look at what they indicate as the problem. So when you check page 21 of the policy, it is a problem statement. What do they highlight? In the problem statement, there are 3 paragraphs, 59, 60, and 61. I invite you to paragraph 60 in particular. In the Ugandan context, there has been a concern of inadequate quantity and quality of education for health. This is caused by, see what they are perceiving as the problem and see whether the solution being prescribed aligns with what they are proposing, they are curing the problem. This is caused by inadequate quality of health trainees. Inadequate quality of health trainees due to inadequate variety of specialized health consultants. Okay? 2, low motivation of clinical preceptors, meaning that even those who are supposed to train as the preceptors, they recognize that they are demotivated. Low motivation of clinical preceptors and consultants. So the consultants are already demotivated. The preceptors are already demotivated. But you again, and you are faulting what is in the university. But you are saying, even while you are still there, you go to these demotivated people, they will still make you better. Huh? Is it to increase the level of demotivation? Should demotivation be a course unit in the program? Lack of uniform standards in examination and academic entry into professional training, as well as an outdated curriculum in a sphere of inadequate mentorship and professional guidance. There are inadequate training materials and poorly equipped training facilities. It is not us who are saying that, okay? Get it? The policymakers, with their level of consultation, with due respect, and the data and the research, analyzing the situation, do acknowledge, they say there is inadequate training, there are inadequate training materials and poorly equipped training facilities. overall, the number of professional health trainers is limited. And so is the investment in continuous capacity development. In addition, there is a lack of harmonized standards in admission and clear structured career guidance and growth, as well as inadequate trainee welfare. The one adding this is here. Inadequate trainee welfare. Interact with the policy, especially on paragraph 60, section 4 of the policy is on the problem statement. This is the problem. If you have analyzed the problem, then you prescribe the remedy. And in respect to policy objective number 6 that dealt with internship, see what they are proposing as the solution. I invite you to page 29 of this policy. When you check page 29 of the policy, is to the effect to enhance, it's talking about under profession objective number 5. It says they are going to develop and implement a plan now to improve welfare of medical interns. Okay, that is paragraph 86 J of the policy under section 7.5 of their policy. They say what they are doing is to improve, to develop and implement a plan to improve the welfare of medical interns. Okay, and what we see then is when we go now to the implementation standards, there are several implementation standards, but I want to invite you to implementation standard number 7, specifically 7.26. It talks about intern welfare, rights and responsibilities. That is page 74 of this document. On page 74, it is clear here. Look at what is being prescribed in the implementation standards. Section 7, standard 7.26, intern welfare, rights and responsibilities. It is clearly stated. There are 2 paragraphs, A and B. A, internship shall be conducted in a manner that protects intern welfare and dignity. Okay? That is the standard. Internship centers and training institutions shall ensure reasonable working conditions. Is removing facilitation a reasonable working condition? From the status quo, what we have already, even with the facilitation which is there, the situation analysis indicates that their preceptors are demotivated. The interns are not really doing well, okay? In terms of training, the quality is really down. Now, for us to solve this problem, this is the standard. Internship shall be conducted in a manner that protects intern welfare and dignity. Internship centers and training institutions shall ensure reasonable working conditions, access to supervision, supervisors are demotivated, and support, occupational safety, and mechanisms for reporting grievances, harassment, or unsafe practices. 2, interns shall adhere to professional codes of conduct. I fear interns are going to steal drugs. They are going to do all the manner of things. Get it? Are they likely to adhere to professional conduct when they are hungry and they are doing all these kind of things? Institutional policies and ethical standards, and shall practice only within their authorized scope and level of competence. Let's go to the guideline. I told you there is a policy, there are standards, and there are guidelines. So specifically, guideline 3.7. Go to page 273. So page 135, sorry. It talks about internship, residency, and fellowship sites. Okay? When you look at paragraph 275, it is clearly indicated that internship, residency, fellowship sites constitute final, and underline that, and most practice intensive stage. Why? Because if you refer back, they will tell you it is a critical stage of transition from you being a student at the university, now you're going into practice. Yeah? We at the Pharmaceutical Society of Uganda, we offer 2 sets of qualifying examinations. For those who have just finished internship, university, irrespective of where you trained from, outside the country and in Uganda, they give you an exam just to check whether you're going to do professional practice independently. So, it is subject to the highest level of regulatory scrutiny under the standards. Accordingly, internship, residency, and fellowships are guided by a number of duties. So they have specified all these kind of duties to provide for what should be done at the site, and also for the learner, what they are calling a learner, who is the intern. Okay? Yes, whereas you are learning, like you stated, 50, 70%, you are there, but you are practicing. At the Pharmaceutical Society of Uganda, all interns are provided with provisional certificate of practice and the registered pharmacist. So now, how are you going to practice while you are still a student? Here, under guideline, just to end with this, under guideline 3.76, it provides, that is page 136 of now the guidelines, and that's where our concern is. It says, paragraph 286, that sites must safeguard trainee welfare. No. That's why we hear saying welfare is a challenge. Sites must safeguard trainee welfare, ensure reasonable workload, the intern is already overloaded. Yeah? Provide access to support mechanisms, and uphold patient safety and ethical standards. Government will continue to support the welfare and subsistence needs of healthy trainees on government sponsorship and guardians for the private sponsored healthy trainees. Okay? But also the language is that government has scrapped everything. Even the minister's communication, say everything. So it's like, are they also reading even the policies? Like as if there is actually also nothing again, another disconnect. So what do we want us to take? So that is the status of things, and we are saying, let the welfare matters of interns be looked into. Let there be revisions of some of these provisions within this policy before their implementation. Let us continue with status quo. Let's improve what is currently there amidst the challenges that we have. We are saying no and no to the internship proposal of seeing that people remain as interns while they are still in the university, and that is only within the jurisdiction of Uganda. It's going to create another gap for those who are going to come here when they trained from outside Uganda. Two, we are saying let there be adequate consultations on some of these aspects, and let us have a consensus. And we are calling upon the members of the Uganda Law Society, you, the lawyers, the advocates, please take up this matter and in your own right, and see that we work together to ensure that there is sanity as far as this area is concerned. We respect our leaders, but we disagree with this policy proposal, and we say they should be suspended. They should not be implemented in the form in which they are currently, for they offend the very spirit of why the policy was developed, in view of the problem statement, the background information, the proposed policy objective, and the standards that have been set, and then the challenge that you have, the guideline for implementation are faulty. And we say, no, please, let's look back into this aspect once again. Thank you very much.
A bigger round of applause for Dr. Lutoti, who has ably broken down the components of the policy, which of course has been a question to very many of us in regard to its content. He has ably broken it down, but he has also brought it to the fore how important drugs can be, either useful or useless, because they can either be drugs to heal you or they can be poisonous, depending on how you use them. These are the people that manage the issuance of drugs to us, especially the prescriptions. We have heard of overdoses, and that is what the Pharmaceutical Society of Uganda is in charge of, which means it's very important for us to listen to them, because without that we could be walking ourselves to the grave. And of course, he has mentioned a very critical position, which is what we are going to take for the day. They are rejecting the policy, its implementation, and or it should be suspended until they have been listened to, and not just as an individual, because he mentioned and said treating or managing a patient is teamwork. You're not going to have prescriptions without a doctor. You know, after we have gone to casualty or wherever it is, the next place you're going, because of course you know there are no drugs also in the hospital, they're going to tell you to walk down to, you know, those pharmacies there. You're going to find Dr. Lutoti. And imagine he's broke, he's angry and hungry. And his internship has been on for 12 months. You have left school, per se, you're a graduate, you hold a degree, and you are on internship for 12 months trying to do both feed your family, but also deliver on your mandate as a medical personnel. This, of course, ladies and gentlemen, brings so much to question, and we are moving very, very slowly, but also in a way that allows the public to understand, and the members of the public that are joining us online. We are receiving your comments. We request that you continue to send them. We shall be reading them very soon, but in the meantime, we want to look further into the discussions and listen to even more able and more current individuals who have so much to share with us. Dr. Lutoti, you have broken down for us the policy objectives, and specifically policy number 5, which is supposed to strengthen internship welfare and remuneration. But also you've let us know that we have 2,216 pharmacists responsible for our prescriptions, responsible for the management of our drugs. You've also told us about the problem. You've easily told us where the document is coming from. And clearly you've helped us to know one other thing as the learners in this house, the REM phase of sleep. We don't know if the ministry has gone into that phase. They are blinking their eyes or something of that nature. But we pray that this will impact how the ministry is operating, the suspension, the implementation, and as much as possible, the consultation with the primary stakeholders. Ladies and gentlemen, we're coming to another speaker. We're going to listen into a very interesting year 1 student of law at Utamu. Very surprising. However, before he went to Utamu, he is a Ugandan doctor, a researcher, an academic, and a health policy expert who was president of the Uganda Medical Association in the 2017 nationwide strike that ushered higher salaries for all civil servants. In 2003, he completed a doctorate of philosophy on policy sciences at Makerere University College of Health Sciences and McMaster University, Canada. The reason we mentioned that he is a year 1 student at Utamu is because Utamu is in partnership with the Uganda Law Society, and he is an example of what we are trying to push for in as far as partnerships with different organizations, learning institutions, and partners that are as radical as the leader of the Radical New Bar, Isaac K. Semakade. Ladies and gentlemen, please welcome with me Dr. Ekwaro Obu.
Thank you very much. I didn't know it was going to be my turn. I was waiting to speak after my president, because you see, I'm not supposed to speak what he's going to speak. But since you have made me stand here, I must speak. I'm a proud law student, and I'm about to pay for the Uganda Student Law Society or something like that. And the one of Utamu, I've been paying school fees slowly. As you know, the economy, we are all responding to the economy. And I'm sorry I came late, but I found that we also started in the African time. Let me start with the end. What is this about? This is about money. It is really about pay. Even if you go to the United States of America today, the leading economy, or China the second, or UK the third, young doctors are always on strike or exploited, even those who have qualified. We can always improve the technicalities which Dr. Lutoti talked about. And thank you very much, my predecessors here, who spoke very, very capably, especially the young ones. Because I was very happy to hear the young president speak. I saw myself when I had the fire. It's still there, but at another level. So the other important thing to say is that let's have remedies. Let's have remedies. And we look at several aspects. Politically, we are saying secure the future. Of who? The future is today for these people. Which future are we securing? So I'll talk a bit of politics. I belong to the Uganda People's Congress. That's why you see I'm in red here. And I thank the lawyers, by the way. You sent me money during the campaigns. And I succeeded. I was number 4 MP in waiting. Because you know the election was very, very scientific. Even if you won, sometimes you are not even announced. But me, at least I got results. Yeah? And I was number 4. I was given actually results. May not have been the true one. We were all given results. One of the options is, we have been in this battle for long with my president. Let me just time myself so that I don't take more than 10 minutes. What time is it? I just want to say these things very fast. Okay, let me try to finish at 46. And we were in a meeting with General Tumukunde. At that time, he was the Minister of Security. We met cabinet, and Professor Rubabinda showed us a pay slip of an intern when he was an intern. I hope this is not what you're going to say. and therefore, an intern was paid in public service. The scale was U5C. And an intern, by the way, was paid more than a general medical doctor, already qualified. And the reason was simple. An intern was working 25 hours a day. Out of 24, he was working 25. And 8 days a week out of 7. Do you get what I mean? So that can be done by government, should not abdicate from paying all interns. You see, what government is doing is bringing back a colonial legacy of divide and rule. Let us pay the government ones, we leave the private ones. It's not fair. It's unconstitutional. It discriminates. And therefore, Muramuri is there, is my colleague. He challenged me, said, but why don't you talk about some health economics? You don't need to go to health economics school to make a simple calculation. What are we talking about? 24 billion shillings. Although they always ask for 35. They say we need 35. But we know that if you pay 1 million shillings per month times 12 months, for 2,000 interns is 24. If it's 2,100, maybe 25, 26. But they always ask for 35. And they account for it very well. So, I calculated at 3,000 interns. Because they are saying there are more, we can't manage. Let's look at 3,000 interns. Okay? What is that calculation? It comes to 36 billion or 35, which is $10 million. I will tell you a few things. That money is there. You have seen how money is in the parliament there. The money of parliament has increased from 600 billion to 1.3 trillion in less than 10 years. In less than 10 years. But when it comes to interns, Tumbavu. You saw the Agora cartoon. They said Tumbavu. You don't matter. Okay? So what is the value addition? There are at least, out of the 2,100, there are at least 1,000 doctors. Each doctor, how many cesarean sections have you done this year? In your? Around 56. The president of interns, thank you very much, has done about 56, because you have to have a logbook, isn't it? As an intern, you have a logbook? But at least you keep a record. He has done 56 cesarean sections. Mothers who are pregnant and are going emergency care to deliver the mother, he has done 56. I think the least doctor could do 10, maybe. The one who is dodgy, isn't it? At least we'll do once a month. Okay, 12. Let's discount to 10. If each doctor, there are 1,000 intern doctors. If each doctor does 10 cesarean sections minimum, he has done 56. Let us cost a cesarean section. If you go to a private facility, how much is a cesarean section? 1 million? Is cesarean section 1 million? In Lacho? In Lacho? 1.2. Let us put that 1 million. No, times 10 cesarean sections. That is 10 million, isn't it? So each doctor who does cesarean section, I've not talked about the pharmacist, I've not talked about the nurses, I've not talked about the dentists, I'm just talking about the doctor alone, is generating value of 10 million. Let us say a whole year, 12 million. One cesarean section a month, just one. They do more, but one. If you multiply by 1,000, what is that? Me, I got 10 billion or 12 billion. 12 billion just from one cesarean section. Assuming they do other surgeries, a road traffic accident of a border, a hernia, okay? Intestinal obstruction. Let's value that at, again, 1 million. All other surgeries they have done, they may be 20 or 30. Let's reduce them and say they are so cheap that they are 1 million. That gives you another 10 to 12 billion. Already just doing that work, they have recovered the 24 billion we are looking for. So it is not that the interns are taking money without returning immediate value to the economy. You can see from cesarean section and any other surgeries, we are recovering at least 24 billion. I can tell you the value is even over 100 billion if himself is doing 56 surgeries. I'm left with 6 minutes. So that is the value addition. Dr. Lutoti, this policy started in 2017. It has been around. But they have been dodging. You know, those days we were fierce. They could not bring rubbish and we tolerate it. And that's why they had to do this one in hiding. We trained them well. But my concern to the radical new, but don't be so radical. You also invite some women that say, a lot of testosterone there, you know, we need to balance. So you brought only men, we are talking tough, but we need mothers here also. Let me speak to the CDF, who now has been given the UPDF establishment. And he can deploy. The current CDF can deploy. The current CDF can promote. The previous 9 or 10 could not. So it's a special CDF. Can you imagine sending a soldier? What does a soldier need to go to Somalia? Or now they are in DRC fighting ADF. A gun, bullets, boots, a backpack, then 2 more important things. Can you send that soldier? Usually they are young, recruits, interns. They send them. Can you send them without food or ration? A soldier. No. Can you send them without leaving him with the money to send to the wife? So the wife knows actually you are working. No. So why are we sending interns to go and die from Ebola? And I wanted to add this value. Dr. Muhammad Ali was a resident, what other people would call student mastering in medicine, surgery, KIU, died from Mubende. That time I was in the National Task Force of Ebola at the IDI. He died from Ebola. He was doing surgery. So what we are talking about is ingrained in the law. It's an occupational health risk. To be an intern, I can guarantee you. We have died. Ours is between, these interns you see here, they stand between life and death. They are not the interns to push paper. I mean, I'm in law school. I know I will do my internship. But at 5 o'clock, I'm going to sleep. You can actually be going to have lunch at 5 o'clock, and a whole truck of guys who have had an accident come. You will leave the next day at 5 o'clock. They stand between life and death. I thought I should distinguish that. In fact, we told Museveni that, sir, if Jesus is seated at the right-hand side of God, these interns are seated on the left-hand side. And you don't want someone who is determining life and death. Let me tell you, the difference is very minimal. The difference can be putting up a line and fluids run, or the guy is just demotivated that he does not put up a line, and you will die, or you will live. So we need very, very motivated frontline health workers. The other point is, you talked about it, I will not repeat very well, the doctrine of separation of powers. If you bring it down to the ground, you cannot be in law, you cannot be the prosecutor, the accuser, the judge, and even the prisoner. You want the universities to enroll, train, examine, they will pass all their interns because they are marketing. So it's an internal contradiction, will worsen the quality. What is the politics? I've talked about protecting the gains. The president is always talking about scientists. Okay? These are scientists. Uganda cannot develop without doubling the number of doctors and nurses. We can even export them if we think they are too many. But let us invest in them. We had moved from I used to earn 500, we moved 1 million, we went to 2.5. We have a letter in 2021 where interns were earning 2.5 million. That is that time when we were saying securing your future. So we secured our future from 1 million to 2.5. Then now we are saying protecting the gains, meaning the 2.5 should remain. But it has gone down to 1 million. So for us, we have lost the gains. So politically speaking, we have lost the gains. What are the labor-related matters? The Occupational and Safety Act, I've talked about. The Employment Act, the Contracts Act. It does not become a contract until there is lawful consideration. You are the experts in law. And here we are saying we must have them employ themselves. It is an constitutional Article 25, forced labor. 44, even if there is a war, you are protected from forced labor. Okay? Unless you're in the military, unless there's a court order, unless you're in the prison, those are, so are interns in prison? Are you made to do internship by court order? Are you doing internship because it is a war zone? These are the things provided for in the Constitution. And then finally, I wanted to talk about money, because this is money. So one time we met the president, he said, you know, for us, he's going to give money to roads. And even if they eat, journalists, you can quote me on this, because they said it. He said it and you remember it. Even if they eat the money of roads, the money will be so much that the roads will still be made. So we are asking the president that you pump money for these interns, give them a lot of money, that even if they eat it, the interns will be trained. We have seen 723 billion given to Day Farmer. Who know, Lutoti, you're a pharmacist. Do you know any drug you are getting from Day Farmer? Metronidazole, which is the cheapest. But I don't know when me have never prescribed any showing Day Farmer. Inspire Africa Coffee, 180 billion. Muramuzi was telling me he's a coffee farmer. I asked him, which coffee comes from Inspire Africa? We have given 180 billion. Luboa swallowed over 200 billion before we saw one brick. Isn't it? So when you look at the total of money which has been spent, it is over 2 trillion. Atiak sugar, 666 billion, no kilogram of sugar yet. I heard Bahati saying, Minister of Trade, that this year you are going to see 1 kilogram of sugar. 1 kilogram of sugar, 666 billion. It is the most expensive sugar on heaven and earth. And we are saying medical interns, 24 billion, too much money, even if it is 240 billion. After all, the money of Atiak Sugar alone can train interns for 10, 20 years at the current pay. The money of Day Farmer can train interns for 15 years. 2,000 interns. So my concluding remarks is that this is about money. This is the National Budget Week. And Dr. Ramadan Gobi said, look here, we have some money. When he launched the National Budget Week, he said, the National Budget Month, he said, we have some money. The second thing he said, there shall no longer be public ceremonies. And he said, the public ceremonies will save the exact amount of money the medical interns need, 24 billion. Can that money which has been saved by Dr. Ramadan Gobi, thank you very much, the economics that works, that's what he says, we want it to work, just bring that money and give to the medical interns. Remember, by the way, Ministry of Health already has money. So what they need is just a top up of even maybe 10 billion or even less. We are not even asking for 24. 10 billion can disappear there in Parliament and they can't even trace it on CSR. So can they, Parliament, give us CSR for interns so that they eat food? Thank you very much. I'd like to thank you for inviting me here. Dr. Semakade. He also gave me a shirt of Radical Nuba. I feel so special because I've entered medical school in style. I mean law school. I've entered law school in style. The full president of the society giving me a shirt. The lady called me and said, what are you giving me? I said, I'm giving you a shirt. I said, I must put it on now and sit with the rest to show that among the 7, one at least has entered the Radical Nuba. So I'm the non-executive member of the Council of the Radical Nuba. So thank you very much, lawyers. I will thank you so much, health workers. You supported me in the political campaign, and the lawyers, once again, thank you so much. I'm very honored to be here. You know, in the law school, we are required to participate in these activities. So once I put a report there, I'm going to get marks from coursework. It's 30%. They told you must participate, you must be. I said, hey, so let me go. When you call, I said, I'm coming in the morning, please. Thank you so much. I wish you well. And let us fight on. A luta continua. This is for our own good. My father was a medical doctor. I saw what he went through. He ran to Kenya, came back. He was in Mubende there. I myself, I got a job in the United States. Very good job working with the discoverers of HIV, University of Maryland. I gave it up. I said no. Because whenever my father could tell me stories, I say it's unbelievable. So 15 years ago, together with these people, Mukuzians, we said we must show the people that the worker must be put at the center of everything. That's why I joined UPC. UPC is the Workers' Party. And we are moving forward with our policies. Forget the history. We are moving forward and we shall soon capture power. Thank you very much.
Thank you so much, dear young lawyer. Oh my God, this is awesome. It's getting more intense by the minute, and we are actually on the same issue. For those that are just joining us, we're discussing the health policy that was just signed, which is being said to be unethical, unpatriotic, and unwelcome and rejected. That is from the health practitioners, from the different bodies. We've just been listening to the former president of the Uganda Medical Association, who of course has given his very, very deep remarks, and he has made mention of critical issues that are going to welcome the next and final speaker, who is going to speak into, of course, the biggest of them, not necessarily saying that there was an order. Dr. Ekwaro, we also know that the next incoming speaker is, of course, where you were once. And of course, we know that he has the issues that are biting the interns currently. So we want to also recognize that you are as important, of course. And now that you have been enlisted as a Radical Nuba ex-com official, we shall initiate you. The rest are going to go through initiation. Don't worry. Right now, we needed to see in which kind of sleep phase they are, but it appears they are all awake. Thank you so much. You have spoken about the money. And now we want to bring in the next speaker because he is going to wrap up all these things. You've spoken about the money, and clearly there is a very good return on investment from the interns. You cannot argue that, because if you're giving us the figures, we're going to receive them. And like we said, this is a moment of learning, unlearning, and relearning. As the lawyers, we're here to learn. But remember, you're speaking to thousands of the public out there who also need to understand better how health practitioning is going on in that area of yours. And you've spoken of the ROI, you've spoken that this policy was started in 2017. Imagine how long it has been in the drawers, and they're bringing it now, which means, of course, it is also time overdue. You've spoken about the ladies. Doctor, this is a very fair ground. We are proponents of rule of law. We cannot have functions without ladies. The truth is, we made contact, and we happened to find that there is a very busy category of interns that are at school. We've been communicating with all these members. They are doing examinations, of course. They are also at work, yes? Yes, some of them have come because they got a day off. Is it 1 or 2 hours off? Something like that. But yes, we are continuing to have this discussion because it doesn't end now. Even if today we have had this discussion, we're going to be following up with you, because after this we intend to, of course, strike a partnership so that we can have these continued discussions. And of course, we have the leaders with us here. We shall be very welcoming in as far as partnership with you are concerned. And of course, you mentioned about a gun, a bullet, boots, backpack, food, and very, very importantly, living allowance, in order for a soldier in the bush to concentrate on the mandate that he or she has been given. So for us, we want to associate with the interns, because that is very critical, because as you've said, they are standing in between life and death. At a very critical moment when you don't have any help, you're going to be relying on an intern who is going to be helping in the cause. You mentioned Dr. Muhammad Ali. May his soul continue resting in peace, because we all remember the effort he put, and yet it ended up in tears, as they say. But it's not very nice to smile at. It also shows the predicament that we are going through as a nation if we're going to lose such very, very critical people of such stature to matters that can easily be resolved. Being an occupational health risk speaks to our hearts as lawyers. So in other words, it says so much for us to be listening to you people, because clearly you're seated at the left-hand side of the Lord, as you have said it, and we want to be close to the Lord. Why not help the interns in order to get closer to the Lord by helping, in order to have you have a sane mind? Of course, we are talking about the appropriation of monies by the government, which asks so much into the questions of what is important to the government. We have just been praying that they be blessed with wisdom, knowledge, and understanding in these next 5 years, having just sworn in, and want to ask ourselves whether the president of Uganda Medical Association aligns with our imaginations and expectations, because he has been given the mandate to speak on behalf of the medical interns as well as all the medical practitioners. And we have with us in the next coming 1 second or two, Dr. Frank Asiimwe, who is going to speak to us as the president of Uganda Medical Association. Thank you so much.
Thank you very much. If I am not able to say anything, I would probably just say that I agree with everyone. A round of applause, and meeting closed. I want to first of all thank the Uganda Law Society, and I'm now being educated that I need to say the Radical New Bar, Uganda Law Society, for this privilege and for this podium. And coincidentally, I wanted to ask for the Radical New Bar t-shirt, but I've been given the T's and C's, and I probably don't qualify. But in honor of my predecessor, Dr. Obuku. Let me ask for the one of back on track. If it's to be bought, I'll contribute. If it requires a course, I'll undertake it, but please bring it so that I put it on as I speak. Secondly, I will begin undressing. Don't worry, I have a shirt and a vest inside, so there will be no nakedness exposed. And also, if that nakedness is exposed, you may not be disappointed. Secondly, I really want to thank the Uganda Law Society, Radical New Bar, for this opportunity, because it's part of our galvanization process. You just don't know what you've just done for us. You have made concrete, made firm our drive to galvanize us. What am I talking about? Amongst us, online and on this table, and as you have seen people submitting, we have got members of the Uganda Medical Association, which has aligned itself with the Pharmaceutical Society of Uganda, which has aligned itself with the Association of Graduate Nurses and Midwives of Uganda, the Uganda Dental Association, the Federation of Medical Interns, Uganda Pharmacy Students Association. Please stand up, and I'm going to give you a minute to speak. We have a lady, ladies and gentlemen, in the house. Federation of Medical Students Association, Federation of Uganda Dental Students Association, Inter-University Nurses Students Association, and I love the color gray. My wife will be over the moon when she sees me in gray. Her knees usually go wobbly when she sees me in gray. So tonight is going to be nice. Okay. So we are definitely back on track. Radical New Bar is where? Oh, it's a Radical New Bar. Oh my goodness, I have been promoted. Thank you. And the galvanization process includes the clinic officers, and this is very intentional. And this is the silver lining on this whole cloud. And you let them keep throwing at us these clouds, these dark clouds. For us, we'll pick the silver lining. We'll galvanize the country. And we've done this before. Dr. Obuku forgot to mention, and I needed an mention from your mouth on this mic, that I was part of your cabinet, sir. You said it. Oh, I didn't hear it emphatically. So I have been in the trenches with Dr. Obuku since 2017. On board, we've got the Uganda Medical Dental Practitioners Council. Because of their appointments, they are silent, but we have them on board. The National Council of Higher Education is with us. So I don't know who is with these policy guys. The deans of the medical schools, 14 of them, and their vice chancellors. We just had the meeting. I don't know whether you attended it. But the vice chancellors were present, and I've not had a single one saying they were consulted. I'll get to that. And the deputy vice chancellors in charge of academics. So I want to thank the Radical New Bar Uganda Law Society for adding our effort to galvanize the healthcare and the healthcare providers in this effort. Let me just pause and invite my sister to say just one or two things, and we continue.
Thank you so much, Dr. Frank. Precious Gracious Ochen, student and a finalist, Bachelor of Pharmacy at Makerere University, at the same time the President, Uganda Pharmaceutical Students Association. Today I stand to speak for all the pre-interns and the students who are still in the system, including those who are still way down in A-level, striving to come where we are right now. And first and foremost, we want to make our stand clear, and that is, unless this policy is reviewed and looked into, we want to promise that we are not showing up for internship come August. Thank you so much.
Thank you very much. Another round of applause. She's made 2 points. One, in this galvanization, we're also galvanizing the biology class in HSC. By the end of this cloud, by the time this cloud is blown away, it's going to be blown away, we are going to be gumitified, completely unbuggable. completely gumitified. This is a gumitification process of the health workers. One of the things we did in this Chisanja, we have a lawyer on Uganda Medical Association. And with this engagement, my counsel at Uganda Medical Association has got her backed up by the Radical New Bar Uganda Law Society. And once you combine us, the energy we have, you combine us with Uganda Law Society. I like looking in the cameras, which one is it? Whoever came up with this policy, you are in trouble because we are coming for you. Let's talk about this policy. And I'm going to try and avoid what has been said in the interest of time. And again, I want to add that I agree with what has been said. First of all, and I'm now going to try to sound like a land friend. Forgive me if I falter. The guys out there, they don't know, but you know if I've failed. This policy is very draconian. It is shambolic. And now it is dead on arrival. Let me break down why I'm saying it's dead on arrival. These are terms we use every day. For us, when you come to us, we must first of all declare, are you alive or you're dead? If we can do this for human beings, how about a document? So my pronunciation is not just based on emotions and sentiments. It is based on my experience. I was an intern 30 years ago. Don't let these looks deceive you. It's the good work of my wife. But I am aged. I am actually reinforced. Even these teeth are not mine. I was an intern 30 years ago. And since then, since 1998, I have been supervising interns. I know who an intern is and what they need. I know the position they need to be for them to be trained effectively. And I'll be breaking that down as we go on. Let me re-emphasize the following. One, an intern is not a student. And I would want you, the land friends, to begin faltering anyone who even mentions the word student in a sentence where they're going to talk about interns. Let it be struck out. I'm now trying to sound like a lawyer. Strike it out. An intern is an intern, period. I must be cognizant of the fact that, of course, the word internship is used in many other professionals. Okay? Many other professional spaces. So, while that must be respected, but a medical intern, for that matter, is not a student. Why? Simple. They have satisfied the requirements for the award of their degrees. If it's MBCHB, if it's B Pharmacy, if it's BDS, if it's Bachelor of Nursing, they have satisfied the requirements. Once you have done your first year and you have passed it, first semester, you pass. If you don't pass it, by the way, you retake. And therefore you cannot finish. So there are all these hoops to jump. In first year, you must pass first semester, second semester, and the, what's it called? The recess. Okay? You do that in second year. You do that in third year. You do that in fourth year. 12 times you have been tested and you have passed the test. In fifth year, it is only the first semester and the second semester, and you pass. 14 times you have been tested. And that is what the curriculum prescribes. Once you have fulfilled those requirements, you have qualified for the award of that bachelor's. And so what these people are trying to confuse us, they are saying we must delay. And they're taking advantage of the provision that the actual awarding ceremony can happen 6 months down the road, 1 year down the road, 5 years down the road. It is not the ceremony we're talking about. We're talking about the qualification. Once someone has qualified for the award of this bachelor's, they have ceased to be students. Now they are what they were studying for. They are doctors, they are pharmacists, they are nurses, they are dental surgeons. But because they have been students, all I have said notwithstanding, they have never worked independently. And because we deal with human lives, we don't deal with just papers. We don't deal with concrete. We don't deal with metals. The first year of practice must be supervised. That must sink in. And it is very unfortunate that the people who have gone through this very same training, who know these facts, talk as if they don't know what they're talking about. What's wrong with them? What phase of sleep are they in? Are they under anesthesia? Are they under some spell or something? They know these things. They've gone through them. So let's settle that once and for all. You can say we are going to disenfranchise these interns, these doctor interns, these nurse interns, but don't call them students. You will be literally trying to get this baby who has just been born, and you are trying to push them back into the mother's uterus. Literally. Secondly, we can argue about the employment status. Are interns employed or are they not employed? Of course, that is relative. If you choose not to employ them, then they're not employed. But let's turn back the dial. Dr. Obuku was telling you about my internship. I started my internship on the 11th, I still remember it, 11th of November, 1996. I had an appointment letter from the permanent secretary. I had a salary scale, U5A4, and terms of reference. At that time, we didn't need a policy because we were civil servants. We were guided by the standing orders. But when this tinkering with salaries began happening, and didn't start now, let me give you again the genesis of this tinkering with the salaries. 1976. I don't know this thing about the sixes. 1976, 1996, 2016. That was our strike with Dr. Buku. We just missed a year. I'm having a heebie-jeebies because I'm Arsenal. 2026. What is wrong with these sixes? 1976, the interns went on strike. Why did they go on strike? President Idi Amin increased the salaries of all doctors. And in his proclamation, he said, the lowest paid doctor should receive so much. I don't remember how much he said. And the very same, we're killed by our own. I don't know what's wrong with guys who climb up there and forget where they passed. What's wrong with you guys? The dean of the medical school then, in the presence of His Excellency Amin, declared that interns were not doctors. When they had gathered in DLT, then Amin told the interns, okay, they have told me you are not doctors, get out. And then how many people remained in the audience? About 3 or 4. He said, then who is striking? What is this all about? Mr. Dean, you've told me they are not doctors. So what is this strike all about? They had to swallow their words. They had to follow them in the quadrangle at medical school. And they had to address them. And their money was reinstated. Why is it that when people reach the Ministry of Health, begin sitting in those air-conditioned rooms, drive in those cars, which we see, by the way we see those cars, you change them often. You think we don't desire them, my friend. The least you can do is just remember us. Remember where you came from. Why are you kicking down the ladders after climbing that far? And you remember when you are climbing up and you are putting on a skirt and there is wind. Okay, trouser also. We might see your nakedness. Up there is not safe. Not safe at all. So, 1976, the interns' money was given. The same thing. 2017. I'll come 2017 and go back to 1996. We went to His Excellency. We convinced him that increased salaries, let the medical officer receive 5 million. He agreed. The intern who is an officer on probation, medical officer, pharmacy officer, nursing officer, on probation must receive 75% because that's what the law says. When you are doing probation, you get 75% of what you're entitled to. He agreed, but also negotiated a bit. And that's how we go to the 50%, the 2.5 million, myself and Dr. Buku and the rest of the team. And then they delayed and delayed, and finally it came in 2021. 1996, the interns then, led by Mr. Doctor, I don't know what to call you because you were an intern then. So if you go by your current dispensation, you were a student, please tell me. Mr. Baliomuns, you led the strike of the interns. At that time, you were receiving 90,000 shillings. And you did such a good job because the salary then was increased to 180,000. So when I started my internship in November, I was receiving 180,000 Ugandan shillings. What did I do with the money? My father had demised a year before. He had left my family with a loan. I took a loan to safeguard the legacy of my father. Doctors are human beings. We have dreams and aspirations. We have responsibilities. Later on, we have mouths. We have stomachs. We want to dress up. How can you be seen to be taking away even the little? We negotiated for 4 million. The president gave us 2.5. You gave it for just 1 year. You cut it back to 1 million. Why? In August, you cut back. Mawada here. He signed the contract to get 1 million after they had cut it. He has received 0 since August. 300 interns have not received that allowance that they signed for, and now you're coming for everyone. You think God is looking at you well, eh? You think you'll thrive, eh? You think all will go well with you. When you have got 300 doctors and interns crying, and now you're going to have 3,000 interns crying. So, if you choose not to employ the intern, we will know. If you choose to take on slavery, we will know. But you'll be breaking a huge precedence. Doctors began being trained in Uganda in 1924 by Makerere, and they have since done internship, and they have since been paid. I can assure you, on top of paying my loan with my internship money, I also bought a car. Yes. Levin Supercharger 1997. Go and Google it. That was like the best car any doctor had ever had anywhere. From internship money. And you think we have no dreams? You think we did MBCHB and excelled for no reason? You think we don't listen to motivations, speakers? We don't have plans? Do we not know that being a nun and a brother is there, and signing a vow of poverty is there? We saw a Hippocratic oath to do no harm, to save lives. Not a vow of poverty. Look at yourselves driving those cars, and you think you are very bright, and for us we are dumb and daft. So, Ministry of Health, if you don't want to employ these doctors, that is your choice. But don't use slavery. Don't use forced labor. Don't use free labor. Most of the things I had prepared have been talked about, and therefore I'm not going to repeat them. Let me just emphasize one more thing. You think power is might. But since I'm here in the Radical New by Uganda Law Society, the wheels of justice grind slowly. But when they grind, they will grind you to fine dust. You may have your say now, because you rushed, you got a signature from someone very important whom everyone is supposed to fear, talk about. I don't. You are rushing with the policy, the laws of justice are grinding. And you are tinkering with things because you think you are powerful. You are going to force Uganda Medical Dental Practitioners Council to license students. Where on earth? How? Under what clause? Now I want to sound like a lawyer. Under what provision of the law will Uganda Medical Dental Practitioners Council license students? Because I like Dr. Rutoti's submission. What phase of sleep were you in? You say one good thing here, and then you contradict it there. Let me just paint one more picture before I end. And of course, in public speaking, when you want to keep people's attention, and you still have like 15 minutes to go, you say, finally, and then they wake up and... So finally, They are hoodwinking us that they want to channel this money for interns to train specialists. Specialists, my foot. When did we ever train specialists? Look at you. We have been training ourselves. Why? We are big boys. By the time you're going to go for specialized training, you have finished your internship. You have been an MOO. You have done your master's. You've done, by the time I went, I am now a transplant surgeon. Do you know how I got there? Did I have any government money? Okay, of course I had some government money. But you forget that we are dealing with pyramids. They are going to bring the evidence. Yeah. Radical Nuba. The medical profession and pretty much most professions are like a pyramid. A pyramid must have a wide base. And as you get higher, it gets narrower. Woe unto him who weakens that base. Just because they're high up there, you weaken the base. The doctors are too many. My friend, you're gomitifying your base. So the least you can do is one, to motivate the base. Let this intern walk in. How much does an intern need? If you can get them that 4 million, me, I'll keep my narrative at 4 million. Negotiation, 4 million.
5.5, it should be at least 100 more than a medical officer. Consistently, you are tired.
Thank you. It takes very little to motivate the intern. It takes very little to keep them patriotic. Of course, Obuku has come and declared that he puts on a red shirt. Me, the yellow one, I never put it on, but it is there. Unless you find me grazing my cows in Chiruhura. We are talking about patriotism. My friend, the patriotism we are talking about these days is not the one of walking barefooted in the Ruelo bushes. No way! At least meet my basic needs. The government is unleashing at least 800 million per parish. They are giving at least 1 million per villager who cares to register. Now, the intern is even worse and less deserving than a villager, part of a parish. Really? After doing 5 years? That's not fair. So, we need to widen, keep our base wide and firm, partly because at the apex where the specialists are, where I belong. I'll qualify what I said. When I went to do my master's of urology, you paid 0 shillings. Okay, I remained on the payroll. That's also okay. But I got sponsors who sponsored me to go and do my master's in urology. What's the point I'm making? And please alert me on the time issue. Otherwise, I can talk until. Thank you. The people who do specialist training can mobilize resources, not the intern. What does he know? What has he been to help him? I had 2 sponsors. Sorry, my wife, I'm going to declare a little details here. When I went to do my postgraduate, my second master's in urology, I traveled and did it in Tanzania. I'm a Christian man. I made a prayer to God. I said, if I'm going to do my master's, my second specialization, I want to be fully funded and I want to go with my family. I got my admission in 2008 when one of the commissioners was doing internship. That's when I was doing my master's. But I postponed that enrollment until I got the first sponsorship, who paid all my tuition. And even then, I didn't go. I got my first sponsorship in 2009. I said I will not go until I get someone to pay my upkeep. It was in the early part of 2010 that I finally got someone to pay for my upkeep. And then I traveled with my family, my wife, my 2 children, my car. I wish I could have gone with my cows. I went. Guys who are going for specialist training can mobilize resources. They can take loans. I'm not saying that you turn down the heat. It is good You want to sponsor specialist training. That's why we need to go. But you cannot be taking the food of the interns and you're giving it to the big boys. That is the malady. That is the disease. You are weakening the base, thinking but that the apex, when it becomes heavy and big, it will collapse because the intern are the ones who deal with the first diagnosis. If I'm working on a kidney transplant, I want someone who's going to pick up patients in renal failure. That is done by the intern. If I'm a urologist, I'm dealing with CA prostate. I want an intern who's going to do a dictorotic examination and flag someone with an elevated PSA. I am not going to see the patients myself the first time. They must go through the base. We are weaponizing this cadre. And it's unfortunate, these are the literal foot soldiers that Dr. Book was talking about, the ones you are sending the front line to fight. Now you are weaponizing them. How? You are stripping them of the qualification. You guys, and you guys online, you don't know that evening when your final results are announced, you are in cloud 300. You do your final exam. I still remember where I was. I did my undergraduate in Bara University. After our final exam, for the first time I went to Lakeview Hotel and waited for the results. 1996, there were no mobile phones. I asked one of the fifth years, as soon as the list is pinned on the notice board, please come and tell us. I went to the swimming pool and began swimming. When the centurion had began walking towards me, I shivered. I tried to read his body language. He disguised. I couldn't tell whether I passed or not. When he told me I had passed, and now I was a doctor, my goodness, I wish I knew how to somersault. That is the pleasure you are taking away from these people. You finished your fifth year, and now the university is being required to hide the outcome. Yes, that's what they are telling them. Hide the outcome. Don't tell Mawada whether he has passed or not, because he's still a student. What are you tinkering with? What's up? What phase of sleep are you in? Come on, wake up. Wake up. I wish I could get you and slap you. Wake up. So you are stripping this intern of their title. And let that sink in. Just look at the officials, and I'm going to keep with the Minister of Health because those are my buddies. The PS is my friend. The former minister was my friend. Balimos is my friend. You are my friends. Just imagine if today you are stripped of just that title, a PS. That you are no longer PS, you are no longer minister. Now turn the clock down and imagine if they strip away or delay. Again, because I'm here, they say justice delayed is justice what? Denied. You delay the proclamation that Mawada has satisfied the requirements for the award of an MBCHB and therefore he's a DR. You have removed that spring from his step. You are weaponizing him. Second, you are telling Mawada that, my friend, the father, your father of yours, who may be dead, or your other uncle who was very sympathetic to take care of you and sold your land and paid you 5 years, now he should also go and sell his own land and take care of you. This man was in Moroto, now he's in Mbale. So Mawada is going to call his uncle or his father, whoever is alive, uncle, now the accommodation in Moroto is more than the one in Mbale. So please send me 10. Hey, my son, but you are now a doctor. Really? And that intern is the one you're expecting to take care of you. When I'm a urologist, so I'm going to begin giving you urological examples. When you're there with your itchy scrotums, and you're coming, and he's the one supposed to take care of you, supposed to deliver your wives, you are weaponizing the interns, and then that is a non-starter. Finally, now I want to appeal to my land friends and ask you these very simple questions. Like a father, maybe I may have quick answers. Do policies override acts? Can a policy which is signed just like that override an act of parliament? Please don't answer me, because if the answer is not in my favor, I might collapse. That some people can sit somewhere in Ginger and pass a policy and it overrides all the acts of fair employment, of fair pay, of contract breaches. Please don't answer me now. Can policies just change curriculums without justification, without due process, without consultation, that you can just change the curriculum without involving the deans of schools of medicine? I will tell you what we are doing in Makerere. We are trying to change the curriculum of med surgery from 3 years to 4 years. And the justification was good. I did the 3-year course. But in those 3 years, you must do the preclinical subjects in first year. And in second year, you must do all the clinical rotations, write your proposal, start your research, and by third year, defend your proposal, do an elective, and all that. So we thought we should make it 4 years. But that change has cost us 3 admissions. Now, how about changing a 5-year course to a 6-year course? So can just a policy change that? So what are we saying? As I've said earlier, the correct diagnosis that we're giving to this policy is draconian and shambolic and is dead on arrival. So, number 1, we are rejecting it. We may not have, again, I'm going to try to sound like a land friend. We may not have legal standing, but for us, we have said no, and we are gumite, and we are being gumitified. We are saying that this National Education and Training for Health policy has been rejected. We have rejected it. 2, and allow me to read verbatim, that we still demand for a policy to guide this training. The only compromise we are making is that this alleged policy should serve as draft 0. Okay? We are accepting it as draft 0 to be subjected to scrutiny by the appropriate stakeholders. And I've labored to mention them, but not exclusively. Uganda Medical Association, Pharmaceutical Society of Uganda, Uganda Dental Association, Association of Graduate Nurses and Midwives in Uganda, Federation of Medical Interns, Federation of Uganda Medical Students Association, Uganda Pharmaceutical Society Association, Students Association, Federation of Uganda Dental Students Association, Association of Intern Pharmacies of Uganda, Uganda Medical and Dental Practitioners Council. These people have no voice because they are on a payroll. And they don't know how to synergize. We know them. Chisule was my intern, for crying out loud. Sorry, Chisule, if I'm putting in trouble. But we have it on record that they were not consulted. They were not consulted. So they are with us. National Council of Higher Education, we are with you and you are with us. That's where your problems. These are the people who must be called to discuss this draft 0. The deans of the medical schools, there are 14, actually there's a 15th coming. The vice chancellors, academic of the medical schools. And there must be an open call to the rest of the public to submit views. Since you are making it a hot cake, let the public come in. Let the Uganda Law Society come in and make its provisions and submissions. Finally, I want to thank Uganda Law Society once again for giving us this platform. And you have added on the gumitification of our cause. I thank you.
A bigger round of applause for the President, Uganda Medical Association, in representation of all the medical practitioners in the country. We are overly excited, elated, and humbled by your presentation, presence, and and position. You have made it clear, as the Radical New Bar will always do, without mincing words. We call a spade and not a big spoon. We also want to associate with 2026 when Arsenal won the Premier League trophy. So I am also an Arsenal supporter. My wife is, as much as you spoke of yours, I am proud of mine as well. There we have the same mind. Nonetheless, we also want to thank you as well for leading by example. You have easily explained to us where you get the locus to speak whatever you've spoken. You've spoken from your heart, and would like to reassure you and the team here before us, as well as all the medical interns that are watching us online and those that are in the building, that we are with you. You have ably spoken to the camera and shared your warning. You are coming for them. They better be notified. So this is a notice of a warning. You're using the Uganda Law Society to send over. And of course, you have made it clear that the policy is dead on arrival. Just like a patient can come to you, the first thing to get to know is whether or not the patient is alive or dead. Otherwise, your 30 years of experience cannot go unstated. You have easily identified with the president of the Uganda Law Society, Isaac K. Semakade. I told you he's watching us. He has sent a message to you that the IT team is supposed to be screening for us. If you watch by the screens over there, we are going to notify the public how far Dr. Buku and Dr. Frank Asiimwe have come. This is them in 2017 when they were together in campaigning for council of UMA that year. That is how far deep they have gone. And that is why they are wearing the t-shirts, because they have the president's back and the president also has their back. If you see over there, those headphones, our most perpendicular president of the Uganda Law Society, Isaac K. Semakade. This is supposed to mean that he has been a part and he continues to be a part. I can see you want to activate the microphone.
Let me clarify. You show the other picture, I clarify.
Yes,
show
Eric.
That picture.
Yes.
Semakade was our lawyer.
Okay.
And those are interns who took Ministry of Health to court.
Yes.
When they had started, again, forced labor.
Yes.
Now, me, I'm there. You can see me very happy in my African shirt.
Clearly, clearly.
Now, that is Dr. Fawuz. Now is the chief medical officer of IHK.
Okay.
There is Dr. Madrio. She's now an obstetrician in Nakasero Hospital. So you can see those ones
where they have come from.
Who are being stepped on.
Yes.
Are the consultants of today.
Yes.
The chief medical officer of CK is Fawuz.
Yes.
Who you are denying money.
Yes.
Okay?
Yes.
And that is Semakade there. He was having his brain trust, legal brain trust.
Yes.
But now he's heading
the society.
The whole legal fraternity,
yes,
in a special way, scientifically from abroad.
Yes. Thank you so much. A round of applause for the president. Yes, please.
I wanted to add context to that picture again, because
yes,
I did internship in 2016, 2017, and that was our time. And our previous interns, they were earning 650.
Yes.
When we shook tables, we earned 850. So in fact, shaking tables helps.
It works. A round of applause for Bang the Table. Bang the table. We say bang the table. We say back on track. Bang the table. Bang the table. Bang the table.
Back on track.
Thank you so much. There we're moving. Thank you so much. We can see we have excited the doctors. You never have this moment to yourself. Doctors are always met at times of stress and pressures, life and death. Always concentrating, but to come here and have you smile and give you hope that it can be better, we are humbled. Of course, under the leadership of the President, Isaac K. Semakade, Senior Counsel, and of course your leadership. If two presidents can align, we were recently also in touch with the President of the Uganda Engineers Association. We had a very good interaction. He happens to be a lawyer. So the President of the Uganda Law Society, this is his baby. These partnerships, these interactions, and remember, you are citizens before you become doctors. So we are also fighting for the rule of law for you as citizens. Remember Article 1, power belongs to the people. So we are very happy for what you've said. We have of course seen the backtracking of the government from 4 million shillings, rather from 4 million shillings that was offered to 2.5, and then again the 2.5 has been cut to 1 million. For 1 million to 0, hence the draft being draft zero, which means you need to be consulted. We want to take this very critically serious, and we want to respect you in the capacities as you've come. We could never have understood better as you have taught us, and a very key thing that the lawyers have learned, and we shall not do it again, is call interns students. Yes, we have also taken cognizance of Precious, who has been in touch with us as well. She had exams, but she has made time because today she had a day off. So, Mr. President, thank you so much for presenting her the opportunity amidst the busy schedule and a lot of speeches that we've been hearing, and would like to make sure that the pyramid that is having a wide base is motivated. From your own words, Mr. President, you are asking that the pyramid is motivated in order for the majority of the interns who have more work than you, like he said. We only come to the senior doctors after a lot has been done at the foundation, at the base. So yes, we know that you are being hoodwinked, but we want to try to ensure you and encourage you that at the Uganda Law Society, you are at home. Solace is unto you, and we pray that the Lord will bless our partnership in as far as getting solutions and remedies to your predicament is concerned. The question you asked of whether policies override acts, the answer is no. It's because acts are really from the parliament, and it takes an amendment to make any changes to those acts. So yes, you're in the right place. You have the quorum, you have the legal standing, because you are an end user of what this policy is supposed to be speaking into. And for that matter, we want to continue to thank you for this opportunity to interact with you. Rarely do we have such opportunities, but under the Radical Nuba, we want to give you assurance that we are going to be with you in the same regard. Mr. President, I would like to let you know, Mr. President, the President of the Uganda Law Society, because we have so many presidents here, we have had an overwhelming feedback along the lines of social media. We've had so many people speaking and giving you flowers. May you please know you have flowers from Dr. Lufafa Godwin, who has given flowers to all of you. He also says, read the names of the brains behind the rebellious policy. Dr. Lutoti has done that. We have also heard from Dr. Ambagira, unpatriotic, unethical, selfish policy trying to impose modern-day slavery on vulnerable Ugandans. Then Dr. Edmond Agaba, thank you so much. You have written spot on. Thank you, Dr. Lutoti, for clear references and those responsible for passing the draft without consultations and review. Then we have UNET's computers, sorry, there's no name to that. I'm sure they have been signing for 2.5 from the Ministry of Finance, but kept giving 1 million to JHOs, which is quite unfortunate. We also have a message from Dr. Alon Nahabwe. He's saying, thank you so much, Dr. Lutoti. We have SB Chibirango. Thank you, our pharmacist, our great pharmacist Lutoti. We have Bwambale Trazik. Why don't we, as the pre-interns, refuse to go for internship this August? I think a year without interns will teach them the hard way. That is quite radical, and we leave it to the leaders to make some of those decisions. And yes, we are also hearing from Dr. Shan. Doctor is in good grounds, dissecting the paragraphs one by one, meaning if he was really consulted, we would not be here shouting, wasting our ATP. Dr. Ambangira continues to say, okay, you know ATP, we don't know it. Energy, okay. Okay, ATP is energy. Members of the public, please note, write that one down. We're here to learn, like we said. Dr. Ambagira continues saying, MOH officials sat somewhere in their AC rooms, just like the president has just been saying, and imagined problems of internship training, because from the looks of it, what they are giving, they are taking away. So clearly there is a disconnect between the end users and the authors of these documents, which of course leaves so much to be desired. Dr. Obuku, you're the guy. You're the guy. Okay, thank you so much for these messages, and would like to, of course, we've spent so much time. It has been a very hot issue. Ladies and gentlemen, we had a lot in stock for you. One was the health practitioners issues. We had other issues that were ongoing, and would like to slip away from the medical room to the courtroom as we transition into the next topics to be discussed. And I know there's so much, and would like to know if there are any questions in the house right now. We want to take one question or two for these gentlemen in here, because we have more or less traversed through the predicament, and we've also come up with suggestions. Would like to know, the president has also requested me to reassure you that we are open, our doors are open for further partnerships. He has also asked me to let you know that it would be right if, by the grace of God, you are able to organize yourselves and formally petition the Uganda Law Society, because you have left so much for us to do. And if only you were able to put it, as you know, we are the lawyers, in an organized manner. And you have a young lawyer over there. He can, hey, student. Okay, he's a student. Okay, semester one. We have a lawyer here. Yes, he kindly requests that we take this to another level. We can receive a petition from the Uganda Medical Association and all sister organizations and bodies, so as to formalize this relationship and see how we can come to your rescue or support. It doesn't necessarily have to be rescue, it is support, because we are one and the same in as far as professionalism is concerned and as far as the practice of rule of law is concerned. Thank you so much, ladies and gentlemen. We have one question from Shamil and another from the gentleman over there. Kindly be precise and concise in your question so that we can get this wrapped with. Thank you.
Ladiko Nyuba, thank you for the opportunity. My name is Moses Munezeru Caxton, an inevitable doctor. I have completed my MBCHB and I wrote my last paper just last week. I'm grateful for this opportunity. My question is, there has been a recent communication on media that we want to improve quality, and I would like to pose a question that how many intern doctors have failed for the last 10 years when our seniors have been supervising doctors. So it comes to our concern that if very many have been failing, then we need to take it up. But if there has been none, then we need not to even give it an eye. Another question is that the population of Uganda is growing day and night, if you have been following the statistics. And it means that the doctors also need to increase, because we need to serve the community that is growing. And therefore, why would it be a point of concern to say that the number of doctors are increasing? I want to also give another question, that if the parliament can be able to increase the salaries of MPs and the rest of the members of the government, how comes they claim that the doctors cannot be able to get their just allowance to just cater for their health? I want to make this comment that the battle we have today is not the battle only for pre-interns, but rather the battle for whole Uganda at large, because the intern is going to suffer, but the community, the Ugandans, the rest of Ugandans are going to suffer, and therefore the service delivery is going to suffer. And our supervisors are going to suffer too. And I call upon the deans of the schools, the universities, the National Council of Higher Education, and UMDPC at large to come up and make statements on this, because they are stepping on the neck of an intern. Not only on the neck of an intern, but on the neck of any other Ugandan. Thank you so much for the opportunity.
Thank you so much. Doctors, the microphones before you can be activated, if you could, you want to ask? Okay. We're going to take one more question, and then we shall allow you use 1 minute each to give closing remarks and your parting shots so that we can roll over. Yes, sir.
Yes, hello, it's me again, the citizen to whom you all account for, and every Thursday I'm always here to make you people account. Dr. Ekwaru Obako, finally, you have come to me. Yeah? Finally, you know, about 10 years ago, I started this fight. I lobbied. Doctors, you thought you were a special class. You thought you were above all of us. First, we are doctors. Those things will not affect us. You know, I'm a qualified anesthetist. Those of you who know, Dr. Lutoti is here. Doctor, you taught me so many years ago, but me, I stopped, I think, in third year. You know why? Because I identified these very issues with the late Dr. Galiwango. We identified these issues a long time ago in Makerere and said, you know what? If we don't start now, you've seen what is happening in South Africa. As Julius Malema says, if I don't stop you now when you're chasing these people, once you're done with all of them, you'll come for us and say, now, you're the one who's the what? Who's the problem? I'm glad I'm glad the problem has finally also touched you people. We fought with the accountants here. Your problem was supposed to have been sorted in 2014. I got a grant from the Singaporean Development Bank. They were willing to give us, let me quote this, $3 billion US. The Singaporean Development Bank, to build training schools in each district of Uganda, each and every district of Uganda. You know what happened? I went to the Institute of Certified Public Accountants. They started cooking those policies. Okay, those who are SCCA, do this. Those who are not SCCA, they cooked up some funny policies there. We fought. Doctor, you went to the courts of law. You've realized that our courts of law are a waste of time. They joke. The Ugandan court system is dead on arrival. Anyone will tell it to you. If you think your remedy is in the courts of law, don't waste your time. Yes, first the radical new bar, our strategy is simple. We bang the tables. But me, I want you to go above and beyond. People are going to hate me, but for me, my issue is, you strike, let people die. When enough people have died, yes, when enough people have died, that's when people, you know, it took us to reach 70,000 in Gaza for people to wake up. You know why? The death toll was not yet enough. So here in Uganda, let me tell you how many people must die from your strike before government takes you people seriously. The figure, it's not a big figure, 10,000 people. Only 10,000 people must die, that's when they will wake up. Do you know why? Because when 10,000 people die, of those 10,000 people, an MP will be affected, a minister will be affected. That is when they wake up. In my district, we didn't have a functioning center for. When I threatened my member of parliament, the following week, it was being built. We got Mabati. They even have drugs right now. That is what happened. Now, for the intern doctors, I'm sorry to burst your bubble. You are students. You see, section 24 and 20, the good thing, Lototi, you are a lawyer, and our first year law student. Section 24 and 25 of the University and Tertiary Institutions Act creates that loophole which doctor was talking about. When I finish all my exams, that period before graduating, that whole, I know why. You know why? I am a victim of that provision. You've finished all your exams, but because of either bias, malice, or anger, the university is putting extra positions because that provision says I can single out some few who I feel that even if they are not properly qualified. But don't worry, I've already done the hard work. I've challenged those provisions in the Constitutional Court. So hopefully, if I can get a contribution of only Uganda shillings, 3 million Uganda shillings from this table here, we push that constitutional petition, it will sort out your issues. But my question to you people, can you please strike a serious strike for like a year or two until 10,000 people die? When 10,000 people have died because interns are not there, Mr. President of the interns, you're here, Madam Pharmacist, you're here, please strike. When 10,000 people have died, that is when they will revisit our policy of 2014. Dr. Ekwaru remembers 2014, and we shall get that money from the Singaporean Development Bank. We shall have training centers in each and every district in Uganda, and we shall not be facing this problem. Thank you so much. Please strike until 10,000 people die. That's the only language that your politicians understand. Thank you.
Over to you. Very, very shortly.
Very briefly, thank you very much. The pre-intern, sorry I missed your name. How many doctors have failed the internship? First of all, failure of internship is not a verdict on your academic prowess. It's not even on account of your lack of skills. Sometimes you can be given extra months because of moral issues, and moral issues are a moving target. You impregnate some cultures, it's okay. Someone, your supervisor may say, we are giving you more months because you've impregnated a nurse. You are caught when you are drunk. In some cultures, it's okay to drink alcohol. So when someone fails the internship, that may not be a verdict on their skills or knowledge, but is a judgment on their global ability to perform. So even before we go to the numbers, that alone cannot be a verdict on the quality of the training. I'll give you an example of a student who was given 6 extra months because they extorted money. When he came to me, he told me that my supervisor didn't like me, blah, blah, blah. I called the supervisor. Good enough, I'd been at university with that supervisor. I said, no, that boy was very good. He was skilled. He knows everything. But he extorted money not once, not twice. So when we are talking about failing to finish internship, it is unfortunate. That's what they are flaunting. They are fronting, but it is not a measure of quality of the university training. But for the record, we've been told that in the past 4 years, only 8 doctors have failed to finish internship. That is a small number, extremely small. That could even be in one rotation in one center. Mulago has got 200 interns. If you came to the internship training committee and say out of the 200, 8 have failed, we will say that's okay, that's acceptable. So that's my quick answer to that one. The citizen, man is too radical. I thought I'd made it radicalism and I was putting it on here. The guy has taken it to another level.
Welcome home.
Oh my goodness. Lessons. I really have no answer to your, because I was also failing to place where you're going with this. Death, we can never justify death, and we cannot ever use it as a tool. Yes. Even when we strike, there must be a standby emergency team.
Yes.
And that is how I was able to bring value to our strike in 2014. As the chair of ethics, I was able to look in the camera and defend that this strike was ethical because we are providing for emergencies. You can never qualify the death of people. Later on, 10,000? Are we fine here? And a strike for 2 years? Internship is 1 year. So that batch going to do internship shouldn't do internship for 1 year, and then another one. My brother, you need to recast your strategy. It has some holes. Just like it's dead on arrival. Your strategy is also dead on arrival. You need to be resuscitated. I submit. Thank you.
Okay, may I just chip in?
Yes, doctor. Yes, doctor.
When it comes to strikes, there we are skilled. And I don't think it's time to strike. You know, as Asiimwe said, when we strike actually, if you look at the literature on strikes, USA, Canada, 8 countries, when you strike, the death rate actually goes down. People don't die. Why? Because you reposition yourselves to go to emergency. The surgeries which can be avoided are avoided. Because sometimes you walk in, okay, what we call elective surgery, cold case, you don't walk out. So all of those deaths are avoided. I also wanted to clarify, the lawyer, whatever the law says, once you are MBCHB, and I want to distinguish this to all Ugandans and all people who have gone to school doing degrees, ours is 2 degrees in 1. Our certificate of the degree reads Bachelors of Surgery and Bachelors of Medicine. So we have 2 degrees in 1, and we are not students in the sense of that act.
We are lifelong students, as the president said. Even him is studying transplant surgery. So we are lifelong students. But if we are students, then we are students who must be paid for our work.
Thank you, Radical Newba. My closing remarks is to invite all the stakeholders listed, including tertiary institutions who are silent on the draft 0. We have just renamed the policy into draft 0. In their silence, they are affected, and their customers who are students are eventually affected, and it is going to contravene the minimum entry requirements and completion requirements that they were set in their institutional policies. So whereas they are seated and they are quiet, they need to actually pull the bull by horns and participate in the ongoing awareness on this policy and advocacy for its retraction. Thank you.
Thank you so much. Just a minute or less, please. Just a minute or less. Yes. Just give your parting shots.
Okay. Thank you so much. I would like to thank the Radical Bar for organizing this. As intern pharmacists, for us, we are open for the engagement, and I would wish to have a policy which is evidence-based that benefits the whole population, not only some few people in government, but even the Ugandan who is at the grassroots.
Thank you. Thank you so much. Yes, Dr. Lutoti, there is no order to eat, please.
Ladies and gentlemen, this is a policy indeed, as we have renamed it as draft 0. And from the introduction itself, the policy is built on a foundation of lies. Even when you don't have much time to read the policy, just read the introduction. You will see that on page 10, paragraph 7, the lie is to the effect that the policy development process was largely consultative, involving stakeholders from both the public and the private sector. That is a lie. The key stakeholders were never consulted. We did not have that sufficient consultation. So we do not believe in lie. And that's why we are saying suspend this policy and let us have. No wonder for every policy, key policy like this, we could see at least a page of a list of stakeholders who were consulted. But the policy is silent on the same, confirming that actually there was no adequate consultation. And those who were consulted need to refund the money because we don't see the value in this process. The policy acknowledges that limited capacity of training facilities and trainers, and that means that it is again irrational for one to think that universities which are over, they are struggling as well to train the medical interns, the medical students, are going to again have capacity to continue overseeing training of interns before they graduate in that process. So we are going to have more incompetent people if we maintain the policy it is and have it implemented. The trainers themselves are demotivated. The policy acknowledges that even the current interns are demotivated. Even with the little facilitation that is being given, they are already demotivated. And so removing any form of facilitation, it increases the demotivation. The policy itself is another lie and a contradiction to what we are hearing in the media from the very policymakers who are supposed to speak. for the record on page 13 of the policy, it is stated that by 2030, Uganda needs to increase the current number of health workers by 80 times. Yet at the same time, they are saying that we are having very many health. So the policy is built on a lie. It is built on all the statistics. It is not consultative. They didn't follow the consultative process to ensure that we have the right data to rely on and have a right policy. The policy offends the doctrine of legitimate expectation. The policy does not recognize the real challenge, and we need to have another opportunity in a room to look at this draft before it is implemented.
Thank you
I thank you so much.
Thank you. Yes, Doctor.
Thank you so much, Uganda Law Society. Thank you so much, my seniors, for the efforts you have put in. As your juniors, we are very grateful and so proud of you. And trust us, we shall handle you very well when those elderly sicknesses come in. I would like to beg the stakeholders that are pushing for this policy. One, skills acquisition is motivated. Please let's motivate our younger doctors and health workers to acquire these skills. Because if they don't acquire them, you might be one of the unlucky people to fall prey of this.
Thank you.
Secondly, slavery will cost us a very noble profession and create monsters. I don't want to tell you scenarios that a monster of a health worker can do, but you can assume them. I also want to tell you that ethics can be better critiqued by the non-teachers of the same doctor. Don't let the teacher who taught to be the teacher to finally pass out a doctor. Lastly, I would like to beg, please pay all interns, even the current ones whom you are not paying. People's families have broken down. People have mentally broken down. Others have started stealing what they are not even supposed to steal because you have made their life hard.
Thank you.
Thank you so much, Law Society, once again.
Thank you so much. A round of applause to these distinguished guests. We want to thank you and ask that the Lord will bless you in this pursuit. We continue to pray. Yes, Mr. President.
Thank you. I hadn't given my closing remarks.
My apologies.
I'll be very brief. Don't worry about time.
It's well.
This policy is dead on arrival. And as a transplant surgeon, I will advise as follows. Take it to the mortuary. That's where it belongs. It is obvious that none of the organs are usable. The group of pathologists can harvest some tissues and some cells which can be used. I'll tell you the tissues and cells which can be used. We can use the skin. We can use some vessels. We can use some valves. We can use the cornea. We can use the bone marrow. But the thing called this policy is dead. And the major organs, the solid organs, are unusable. But some tissues and cells can be used. It is therefore declared as draft 0. If they bring it to the right people, we can make something out of that clay. It's as good as clay. Thank you.
Thank you so much. Finally,
I should have said it after my president, but I want to take us back to August 13th, 2016. Grand Imperial Royal Hotel. Imperial Royal?
Yes.
I was the MC, and we had the first Grand Doctors Fellowship dinner. I was having the microphone, and the president was our chief guest. We had similar challenges. When he understood, because that time we didn't talk, we just let the SHOs and the interns talk. He said, "Hello, you mean in my regime, I have people who are working and not being paid? Modern day slavery shall never be part of my regime. Minister, go and correct that one." That was the first time a resident was given money for working. To date, I want to implore the president, I want to implore the people who work for the president, I want to implore the owners of the money to ensure that doctors, nurses who are doing hard labor, modern day slavery is not part of that. Thank you very much.
Thank you so much. A round of applause once again for all of you. We are overly honored to have received you. You have done the topic justice. We have shot so much into the time of the other individuals, but this was relevant. We don't want to take it away from you. We are also patient in this house because what you're raising affects us as well. It's not just you people that are in this predicament. We're, at the end of the day, we are weaponizing the cadres by this policy being implemented. So your coming to us helps wake us up to get out of the slumber phase of REM. We are thankful so much for your point. We want to excuse you, but before you leave, we would like to take a picture over here with the members that have come. In the meantime, we were joined by the Vice President of the Uganda Law Society, Advocate Anthony Asiimwe, who is very honored to also to be here, and would like to request that you join us. Adam?
But you move this thing.
No,
it has to be
this
there.
is a design.
Yeah.
This is a design. This is Thank you, thank you, thank you. The House is being called to order. We are still moving. Ladies and gentlemen, we would like to also request that the doctors can stay around and listen to the legal matters, because we have listened to the health matters. Now there are also some legal matters that are being brought to the fore. We would like to thank you so much. As we get into the second session, the second and last session, we would like to ask that we put our minds to task in regard to the next item. Yes, yes, some order, yes. Some order. Could we kindly take our seats? Adam. I want to engage. Thank you to the doctors. I can see people are making connections and making networks. Dr. Frank, thank you so much for your presence. We are proceeding with the next item on the agenda. After healthcare, we're moving to justice, concerns about preservation of rights, and so we are turning to the judiciary. I know we are in very, very high moods after listening to the doctors. It is about that time that we switch our attention. I would like to kindly request that we reorganize ourselves. We are not going to go through so much because ours is a discussion of paperlessness. Ladies and gentlemen, kindly take your seats. Let us organize ourselves and we can get into the item that has brought us here in regard to the judiciary. Ladies and gentlemen, we know those that are online, we don't want to take your time for granted. Thank you for continuing to be with us. We appreciate the moment and would like to use these next few minutes or an hour to discuss our item of interest. Now, recently the judiciary announced that effective 1st July 2026, the court operations shall transition towards a paperless system. This vision, of course, has been said to be very commendable because a modern judiciary should embrace technology, which, of course, promises faster case disposal, reduced administrative costs, better record management, and greater transparency in order to have access to justice. And of course, as you've noticed, the radical new bar under the leadership of Isaac K. Semakade, Senior Counsel, has been at this using the D that is amongst the 4 Ds, that is digital transformation. So we are very alive to what the judiciary is going for, and the Uganda Law Society cannot be done away with in as far as operations to do with access to justice is concerned. But of course, we have a very, very critical question that keeps being asked, and the question is, can a digital destination be achieved without a digital foundation? Because many advocates, ever since that announcement was made, as was announced by the judiciary, something that was brought to us by the CEO in her opening remarks, the questions have been very many lingering in the minds of the public and the judiciary and the advocates who are the users of these courts. Many advocates continue to face connectivity challenges. Several court users lack digital literacy. Numerous judicial officials and court staff require further training. Internet penetration is still very low, and power interruptions remain common, which of course begs the question of whether or not the judiciary and the public or Uganda at large is ready for this migration. With us today, we have very able lawyers with us who are going to discuss this issue, following from the paperless symposium that was held last week under the leadership, of course, of Paul Muchibi, PM Digital, who was very, very helpful to open the minds of the public and the minds of the lawyers, in partnership with the Uganda Law Society, in which we had presentations from the president of the Uganda Law Society, we had presentations from the vice president. In other words, the Uganda Law Society was ably represented, and we want to pick up from there because it's an issue to be talked about without looking away from what concerns us and our practice. To help us unpack this discussion as to whether or not we are ready for a paperless judiciary, we have with us able speakers, and we are going to use them here to the fullest because we want to bring to your notice as lawyers, but also as the general public, as to whether we are ready for a paperless transition, which of course begs into the questions of how can what the judiciary announced to be taking effect on 1st of July, which is less than 30 days from today, be said to be ready, and what solutions to that effect are we going to have to discuss. This is going to be an ongoing discussion. It's not going to be a one-off. Today we are discussing a paperless judiciary and whether or not we are ready, but in the coming weeks towards the 1st of July, but also beyond that, we shall be actively having these discussions at hand. So, ladies and gentlemen, I would like to welcome to help us unpack this topic. Of course, with the members that are here before us, we have been joined by the treasurer of the Uganda Law Society, the governor, Advocate Arthur Isiko. Thank you so much for making time amidst your schedule. We earlier on announced the presence of the vice president of the Uganda Law Society. We want to appreciate you, Mr. President, Mr. Vice President, for your time also, because we all know how engaged you can get, but also would like to appreciate the presence of the Acting Secretary General, Advocate Sally Babu, for making time for this very critical topic amidst all the different schedules. We would like to invite a founder of a blog that is one of the spaces where creative prose meets critical institutional critique, which isn't necessarily just a blog. It is an intellectual background dedicated to challenging the status quo, exposing systemic inertia, and demanding accountability. Whether you are a student navigating the system, a practitioner looking for reform, or a curious mind, you have a seat at this table. This platform is meant to bring legal ideas to the fore, just in your handset or on your phone, and we want to use this opportunity to interact and get into the mind of this very, very astute Radical New Bar follower who cannot go without saying, because he has always been here with us, he supports us in all ways possible from the different angles, and is a part of the Judicial Affairs Committee of the Uganda Law Society, and we have an advocate with us. And ladies and gentlemen, please welcome with me Advocate Enen Ambrose.
Thank you so much for that very warm introduction. My name is Enen Ambrose.
We are very sorry for that mishap. There was a little bit of a communication gap. We would like to welcome the Acting Secretary General, who is going to read unto us a statement that will, of course, usher us into the presentation that Advocate Enen is supposed to make, and that will also be followed by the next speaker into the program for the day. Once again, please, we beg your indulgence. Thank you.
Thank you, Robert, and sorry for that. Good afternoon, colleagues. Yes, I wish to thank the members of the Uganda Law Society who are present here today physically, members of the Secretariat, the Rule of Law Department, and members of the Uganda Law Society and the public who are following online, and also our panelists for the time they have sacrificed amidst their busy schedules to be here, especially Advocate NN, our legal blogger from RNB, and also Advocate Galandi, as well as my colleagues of the Radical New Bar Governing Council of the Uganda Law Society, that is the Treasurer and Vice President, as well as also our colleague Advocate Sempala. I am here to read the statement on the constitutional eligibility for ministerial office and the need for the transparent vetting. But however, before I dwell into the statement as written and approved by the Radical New Bar Governing Council, I wish to state that the said process is still ongoing and the vacancy has not yet been filled. We are aware there is a lot of speculation between what happened in the appointments committee and whatever happened therein is only known to the members of the said committee and the person who was vetted. And we should also know that those who participate in this process take the oath of secrecy and are bound by the same oath until the said report is sent before Parliament, which does not also debate on the same but rather sends it to the President. So let's be calm and advise everyone involved to actually be calm as well, because we've seen several accusations and counter accusations in the media, including a statement opposition that was sent by Professor Muganga on his social media platform. But however, as the Uganda Law Society, we've also seen that several of our advocates have gone ahead to discuss the said matter on media platforms and radio and TV as well. That is what compelled the Radical New Bar Governing Council to also come up and advise everyone involved objectively, and hence coming up with a statement that I'm hereby going to read to the members of the public. Kampala, Uganda, and it is dated 4th June 2026. The Uganda Law Society expresses regret regarding the position taken by Dr. Lawrence Muganga on questions of his eligibility for appointment as Minister of State for Internal Affairs. Questions of eligibility for high public office are not personal attacks, but issues of constitutional and statutory compliance. The clear legal provision is ambiguous. That is Article 15.7, that is Sub-Article 7 of the Constitution of Uganda, which empowers Parliament to prescribe offices of state that persons holding dual citizenship are not qualified to hold. This is operationalized under Section 23 of the Uganda Citizenship and Immigration Control Act, Cap 313, and the 5th schedule thereto, which explicitly bars dual citizens from holding offices, including cabinet ministers and ministers of state. That schedule may be amended by Parliament by way of resolution. Citizenship is fundamentally a personal matter. It becomes one of legitimate public interest. However, when an individual seeks appointment to high public office with national security responsibilities, Uganda Law Society does not as a policy investigate or make pronouncements on citizenship matters. We are compelled to comment here because Dr. Muganga himself invited public scrutiny by addressing the vetting process on social media. This is an exceptional case that requires full clarification and adherence to the laws by all parties. Pursuant to Section 3, subsection D of the Uganda Law Society Act, we strongly caution Dr. Muganga and his supporters against framing legitimate legal scrutiny as anti-Rwanda hatred, tribalism, or racism. Such statements made without verification risk polarizing public debate, weakening respect of rule of law, and shifting focus from constitutional requirements which are at stake. This matter does not reflect xenophobia towards holders of dual citizenship. Dual citizens remain valued members of Ugandan society in their private capacities. Schedule 5 restrictions apply narrowly to specified offices of state for sound reasons of sovereignty and undivided allegiance. A call for open parliament. We reiterate our call for genuine, open and transparent parliamentary vetting processes. Rule 179, sub-rule 2 of the Rules of Procedure of the Parliament of Uganda state that Parliament is responsible for the current closed nature of these processes and must be scrapped by the 12th Parliament to allow meaningful public participation. Owing to intense public debate over these accusations and counter-accusations, the Uganda Law Society Governing Council has resolved to formally request the Appoints Committee for a committee report. This will enable us to scrutinize the vetting process for compliance with constitutional and statutory requirements for cabinet and other ministerial offices, and to set the record straight. We urge the new parliamentary administration to comply with this request without delay. Xenophobia in all forms must be combated. This isolated case of constitutional scrutiny must not be misused to stoke division and prejudice against any community. The Uganda Law Society remains committed to the supremacy of the Constitution, the rule of law, and protection of Uganda's sovereignty. All public appointments must be strictly compliant with these fundamental principles. Issued by the Uganda Law Society Council this 4th June at Uganda Law Society House, Kololo, and signed by all the members of the Radical New Governing Council. And as I stated in the beginning, the process is still ongoing, and therefore members of the public should not in any way continue with the ongoing criticisms, because the said report has not yet been forwarded to Parliament, which shall also not debate the same, but rather take it to the appointing authority, who has the final say on this. And therefore, if Dr. Muganga can prove the absence of dual citizenship, they said his vetting can be scheduled again at an appropriate time, and all this discussion, the premature discussion that is in the public domain, can be put aside. Therefore, what we advise the members of the public and Dr. Muganga himself is to desist from being in the media and wait for the process to proceed, because the same is still premature. Thank you all, and I can now probably take the opportunity to call back Advocate NN, who was introduced earlier as one of the Radical New Governing Council certified bloggers, to come and speak to the members of the Uganda Law Society. We have read on several forums. He has come up with Yes, yeah, he's a certified radical new blogger. And he has come up with a site which has very interesting material. He has severally asked members of the legal profession, that is advocates and lawyers, they could be students and members of the public, to subscribe, because I think he also wants to grow the same, but it is mostly related to adherence to rule of law. It talks about several aspects that are in public domain, like corruption, and then it tackles independence of the judiciary. So I believe that whereas the same is not on agenda for today, he could also address members on the same, because it is one that is really interesting and needs to grow. Thank you. You're welcome, Advocate Emmanuel.
Thank you so much, General Secretary, for inviting me once again. I can't thank Councillor Robert enough for the earlier warm introduction. Good afternoon, first of all, everyone here. Yes, I'll go straight to delivering the presentation titled A Paperless Judiciary, Why Aren't We Ready? A speech presented by me, N.N. Ambrose, a blogger at www.nnlegalworld.com at the 18th Rnblive, today 4th June 2026 at ULS House, Kampala. The President of the Uganda Law Society, Isaac K. Semakade, Senior Counsel. The most perpendicular Vice President, Anthony Asiimwe. My Northern Uganda representative to the ULS Governing Council, Council Egaro Emmanuel Omiat. Elder, whom I believe is following us online. The General Secretary, who is the precurrent speaker, together with fellow members of the ULS R&B Governing Council. In my own lingua, I prefer to call them the ULS R&B High Command. Distinguished members of the medical fraternity, although they have already left, but I'm sure they are following us online. And all the citizens following us who are present here and who are following us online. I was invited to speak in my capacity as a blogger at www.nnlegalworld.com on the theme, A Fully Paperless Judiciary, Why Aren't We Ready? I stand before you today with deep humility and sincere concern as a technology enthusiast who believes that technology must facilitate access to justice rather than impede it. I have witnessed firsthand the challenges that arise when we rush into a fully paperless system without adequately preparing the people it is meant to serve. What I have observed is not mere technical inconvenience. It is something far more serious, a subtle but damaging form of harm, which I prefer to call the quiet violence of procedure, being done to the very people we are sworn to serve. I go to part one of what the crisis is. The quiet crisis. I am not making reference to a violence of guns or of angry mobs. It is the quiet, daily violence of a system that pretends everything is working when it clearly isn't. A few days ago, the judiciary's deadline for crossing into fully paperless operations came and went. And in the public discourse, we are now aware that the judiciary's ICT director confirmed that the system will only be rolled out to 49 courts, which represents 20% of the total courts that are operational. I want to provoke your imaginations, members. Imagine a magistrate who cannot access a bail application because the network for the judiciary's flagship program, ICMIS, has failed. The system will coldly declare that there is no file, and the judicial officer will tell you that I can't see your application, I can't see the file before me. And yet the accused, whether a poor market vendor, a struggling farmer, or a respected professional, stands right there in the dock. When this recently happened to an advocate, that person was remanded to Luzira prison. This one now jumps out of the box of imagination. It actually happened to a member of the profession. We have always been told that justice delayed is justice denied. But members, present and online, what do we call justice that has simply disappeared from a screen? We are rushing into a paperless judiciary while many citizens, and even many lawyers, still cannot navigate it. If a poor person cannot understand their case without a single sheet of paper, have we really advanced? Or have we simply replaced one barrier with a more expensive and more frustrating one? Colleagues, I would like to invite you to go on the ground, and we put our boots on ground with me. The concerns that I've alluded to are not theoretical. A recent survey by the PM Digital Law Hub revealed very worrying numbers. 1, 87% of judicial officers and advocates have experienced frequent system disruptions. 2, 78% who participated in the study reported that technical support is unreliable. 3, 67% were not confident that we would be ready for the June 1st deadline. It's actually June. Yes, it's June. The circular is out there. And then fourthly, 59% reported that they had received no formal training at all. Now, those are numbers, and lawyers, we know ourselves, we are the anti-math club, with a few exceptions of accountants who crossed to the legal profession. Let me give you a picture of what these numbers actually mean. A few years ago, I sent a bright, confident legal assistant to the Gulu branch of the Uganda Registration Services Bureau. His task was to certify company records, which we needed as evidence in court. He knew the registry, he knew the staff there. He was polished and fully prepared. But when he arrived, the physical counter was still there, but the records had already moved online. The staff of URSB turned him back empty-handed. And they informed him brutally that what you have come to do in the analog way has now been digitized. Go back to your chambers and do what you have to do. That day, we had no choice but to force ourselves to adapt to the new technology. That, colleagues, is exactly where many of us are today with ICMIS. We are still walking the old path, trusting the old corners, while the world has moved on. Maybe that life story is not enough. I think I should add something more. Let me tell you another story. It has not happened yet, but will happen if we are not careful. Let me add something off-head. I'm pointing to an existential problem for the profession in the not so many days to come. I want you to meet an imaginary lawyer. Baptize that lawyer any name you want. She is very experienced. She's practiced law for 15 years, and one afternoon she receives an urgent call. A client is about to be evicted. A temporary injunction application, as well as an interim injunction application, must be filed before 5 p.m. She knows the High Court registry well. She has done this 100 times or more. But when she arrives, the counters are gone. The clerks point to a sign. All filings are now electronic. Use ICMIS. No paper accepted. This lawyer does not have her laptop with her. The courthouse Wi-Fi is down. Her phone battery is very low. She tries to log in, but she has forgotten her password. She calls her clerk, who, you know, clerks go on their chair. In the Luganda, you know, they say, Avera Iriva. It's okay. Thank you so much. Yes. Yes. So, the clerk's phone is off, or rather, it's not answered. The clock shows 4:47 p.m. She has her manual papers. Okay? Her client will be evicted tomorrow, and there's nothing she can do. Colleagues, the judiciary's February 2026 circular paints this kind of future for all of us. And if it is enforced fully without the changes that were proposed in the recent symposium, and more that I'm going to propose today, this risk in the imaginary story will happen. I can guarantee you that in the streets where I be chilling, they say we can bet. The lady lawyer will stand in that registry fully unarmed and disempowered. In that moment, like my legal assistant at URSB, she will learn the hard way how she was trained for a profession in a way that is no longer relevant. She must upgrade her digital skills or risk being rendered irrelevant. The section I'm going to is more of a cultural problem. In 2026, we still have judicial officers reaching for the civil procedure rules, a set of laws, a set of practice law which first commenced in 1929, to determine the validity of a summons delivered through a WhatsApp message. This is about a live case. It's on my blog. While the entire body of laws enacted to facilitate digital transformation of the judiciary gathers dust. Without clear practice direction and without digital competence forming part of performance evaluation, even the limited rollout to only 49 courts risks becoming a spectacular failure. Now let's go to the human cost of this. It is reported that our advocates, the lawyers, are now working at 2 a.m. Not because they are very, very dedicated compared to the rest, but because the system is too slow and congested during the day. For those who are conversant with the technology language, this is called a bandwidth problem. And therefore, we have in effect outsourced government server problems to the sleep and mental health of lawyers. A joke used to go that if you want to do family planning, you should stay in Mukono, because the traffic from Kampala to Mukono will force you to do what we call involuntary family planning. Now, this deadly occurrence where lawyers are now trying to upload documents at 2 a.m., I also want to call it a sort of family planning, involuntary family planning, because you don't have time for other business. This is not digital transformation. It is like constructing a magnificent house without laying a proper foundation. Very impressive on the surface, but unsustainable and harmful to those who must live in it. We have a new problem. I spoke to one of the elders who is no longer serving, called Madira Jimmy, an Arua-based advocate. He is known by his alias, Lord Madira. I'm speaking towards what we call asymmetry. He warned me that many lawyers in the north, and north is only symbolic, meaning the whole of upcountry where ICMIS has not been enrolled, risk being reduced to local assistance, or rather legal assistance, for Kampala-based lawyers who have better internet and support. They have the same law degree, the same oath to serve, but a completely different and unleveled playing field. This, in effect, creates a dangerous hierarchy inside our profession. Now let's touch on some issues to do with accountability. The vanishing file concept. Under the old physical system, a file could be traced. Today, an urgent application can simply disappear in the ICMIS system. You have come to court, you are ready to proceed, you have introduced your land colleague, and the judicial officer is saying, "Counsel, I am not seeing the matter you are preparing to address me on." A judicial officer who does not wish to attend to a matter no longer needs to hide the physical file or collide with their clerks. They just have to simply say, the system doesn't show your file. And who can argue with a screen they cannot see? We recently experienced this when Uganda Law Society filed an urgent human rights application concerning the Gaba trial. For those of you who have been following, the concern of the bar was a principle called venue neutrality. That application was effectively not attended to. In my humble view, these incidents point not only to a potential case of misconduct against the concerned judicial officers, but more importantly, to a deeper and disturbing lack of accountability in our digital justice system. If what happened regarding the Gaba trial could be done to Uganda Law Society, a national bar association, we can't help but wonder, who else is suffering the same fate? Ordinary citizens who have no voice or remedy at all. Just figure out those villages. A village like Napumpum in Kotido, a place called Anyeke in Oyam. There's another place called Mparo. I'm not sure which district it is, but there's a deep village called Mparo. Those citizens who are not at the same level as a national bar association, are we sure they're not suffering silently already? Or they will not suffer when this system is fully rolled out? So what must we do? Enough of the lamentations. I'm not here to condemn the bar or the bench. Neither am I a doomsayer. My critique is directed across the board at all of us who have a role to play in the successful adoption of digital transformation in the administration of justice. Number one, the network is down problem. My suggestion is this, and this one is for the architects, the software developers. Mandate something we call offline functionality. Every court computer must be able to do what we call pre-catching daily and routinely, can even be hourly. So that when the network is off, you simply toggle to offline mode. And therefore the excuse that network is down and you cannot access a file, it just vanishes completely. So this is an architectural issue in designing these digital systems that we use. Regarding lack of skills, mandatory training. This is where the Bar Association comes in. Those who offer CLE points, please do us a favor. Partner with the Judiciary Ichmis department to offer CLE training to members of the bar. But then, maybe more interestingly, I conceived an idea called the TOT, the Trainer of Trainers program. Myself, I'm willing. I am not very badly off with the technology. But if there are lawyers willing to volunteer, to be called into one place and trained, then these lawyers can become trainers of trainers locally in their regional bars where they practice from. Number 3, recognize modern communication. We have a whole set of laws starting from the Electronic Transactions Act and the recent 2025 regulations that govern the use of Ichmis. They themselves are not enough. You know, a practice direction operationalizes what is in the law or what is in a statutory instrument, so that we don't have decisions which say, and this one I'm quoting from a known source, those who have followed my blog, they know, you don't have to say that you need leave for substituted service in order to serve somebody via WhatsApp. Because a WhatsApp service is actually done on a person's direct personal handset. Okay. So we need those practice directions. The court can always have a fallback position where they believe that injustice has been shown. Number 4, a true hybrid system. And this one I'm very glad. At least Judiciary told us that they're rolling the system to only 20% of the total courts that we have. But then, my recommendation is that as we are doing digital, we should accompany it with paper, side by side, until we are now conk sure. The word conk is, I don't know if it's used across the country, but it's short for concentrated sure, like conk acid, until we are conk sure that the digital platforms are 100% foolproof. Citizen-centered design. The system must work for everybody. I mentioned those villages. If a hearing notice is uploaded on Ichmis, and I argued this in one of my blogs, I said, if a hearing notice is uploaded on Ichmis, and we are still in transition for all these years that Ichmis has been in place, I think lawyers should be handled with some grace. If the assumption right now is, if a hearing notice is uploaded, it doesn't matter whether you receive an email alerting you. So, citizen-centered design means the client receives a notification by SMS saying, your case has been fixed for this day. For more information, please contact your lawyer. I think that would serve a lot. Number 6, we need to cultivate deliberately a transformed legal culture. Digital transformation without a corresponding culture of accountability and citizen-centered justice is merely digitizing the old bad manners. We must deliberately build a new legal culture where technology serves justice rather than concealing injustice. Number 7, we must embrace technology at individual and institutional level. We must consciously cultivate a new culture of embracing technology at both personal and institutional levels. A lawyer who boasts that they never read their emails or deliberately switches off their WhatsApp blue ticks is not different from a judicial officer who conveniently and falsely claims that they are unable to see a file. True digital transformation demands personal responsibility from all of us. The call to action, fellow advocates, we must continue having honest and regular conversations about digital transformation and the development of a new digital legal culture. Our shared goal is to ensure that technology truly enhances access to justice for all. Let us speak constructively with one voice for the good of our clients and the future of our profession. The judicial officers, my clarion call to you today is this. Many of you are working under very difficult conditions. Let us join hands and fight together for better tools, better infrastructure. I spoke about bandwidth and capacities of servers, and better support. As the ancient proverb teaches us, and I have merely adapted it here, the roots of accountability are bitter, but the fruits are sweet. This is a variation of Aristotle's famous saying on education. Let us therefore courageously cultivate at both personal and institutional levels a new legal culture of accountability and genuine digital transformation. The people of Uganda walk with us from a widow deep in Amudat who has never opened a PDF to the accused in Luzira whose application vanished from a screen, and the nocturnal lawyer awake at 2 a.m. fighting a congested server. They need us to get this right. Our spirit is willing. We must now strengthen the flesh of this system. I thank you, and I remain Enen Ambrose of Enen Legal World, a legal literacy blog, which you can find at www.enenlegalworld.com. I say this for God and my country. Thank you so much.
Thank you so much, Mr. Nen. You have ably broken it down, which of course is the reason we're here, to help the public and other lawyers and the membership of the governing council to understand exactly what the common man or the lawyer out there or the old lady out there in Apache district is going through in as far as the ultimatum by the judiciary is concerned. You have ably shared what is the challenge, and of course they are very apparent, especially for those that are practitioners, and we associate with what you have shared. Only yours comes with, of course, experience, and you've been able to share yours, but if you hear the account of the different advocates, it's nothing any different. Recently, the Vice President was speaking at the symposium last week. His scenario would leave you wondering whether he's actually the Vice President, because this technology doesn't know whether you're the Vice President or not. If the Vice President, as you've said, is going through a challenge, and then you're not an advocate, you're going through the same challenge, imagine what a person in Vara, Arua, or Kwen district, or Chisoro, deep down where network is not, is going through. We want to associate ourselves with the solutions because you are a part of the Radical New Bar philosophy and very much proponent for digital transformation, and it's very important to have these critical discussions that will help to find solutions that we can stand tall deep down over time for posterity purposes, that we did our part when it came to this particular aspect of transition, especially as we are executing our mandate of access to justice, especially to the indigent, but also to the country at large. The solutions you've given are very critical. I'm sure everybody has listened to them, but summarily, we want to ensure there is a mandated offline functionality, which I know very many lawyers would love to hear, because that is the ultimate solution in case network is a challenge, because even just as we are, the internet coverage in the country is very, very low. So imagine if we're all tied to using internet and yet you are not in an area of internet. You've also spoken about CLE trainings. We have the vice president and the representation of the high command, as you call them, who are listening. Be sure that those are some of the aspects that are going to be inculcated in the training program for CLE, so that lawyers are given an opportunity to learn and get better. Of course, you've spoken about the TOTs, which is a very important thing to allow it to be done locally without having to engage overly the judiciary and ECMIS staff. Yet we can easily have fellow advocates that can be able to be used to help train others. And recognizing modern communication, having a hybrid system, and having a citizen-centered design, and especially that means we want to cater to the local citizen who knows nothing about internet but can easily receive a text message regardless of location, as long as he or she has access to his or her lawyer. Advocate Enen, thank you for making it from so far away. We thank you for the journey that you took. You came into the city after a very long journey from Germany. We want to take cognizance of your effort. It was not something to be taken for granted. Let's give him a hand clap. He has made a very good presentation, and we take all these issues that you've raised very, very seriously. Your presentation has been very helpful to the citizens, the advocates, and the general public, including the judiciary. Ladies and gentlemen, we're going to listen to the founding and managing partner of Diamond Advocates, a partner firm with one global, unified international firm in law, tax, audit, accounting, and business advisory in the UK, the USA, etc. He is a co-founder of LexTech AI Company Limited, a company behind LexChat, an AI research assistant for lawyers, and is also a tech lawyer who is widely celebrated for different achievements. He has to be given flowers. He led the Tech Fest of the Uganda Law Society. That was our inaugural Tech Fest session, which could not have been possible without the leadership of the Radical New Bar Governing Council, the High Command, as Enen calls them, but also his stewardship meant so much to the success of the Radical New Bar the Radical New Bar inaugural Tech Fest. He's also the founder of Law Tech Associates and Consult, a company behind the Legal AI Research Assistant and the Msezi app, connecting clients with legal professionals. He can help you to get connected to a lawyer if you cannot access one easily. Then that, of course, means he runs a Legal Tech Dialogue podcast, which he does every Thursday. Today, please don't hesitate to tune in from 7 p.m. The links will be shared on the different apps or social media handles of the Uganda Law Society, because he is a friend and a partner of the Uganda Law Society, and he is a very respected legal tech and AI advisor, having worked with local and international labs, including Makerere AI Health Lab, and serves on Government of Uganda Ministry of Health Committee Shaping AI in Health Policy. Ladies and gentlemen, please welcome with me Advocate Galandi Tony Kire as our next speaker.
Thank you very much, Advocate Juro. I suspect that my accountant has put Advocate Juro on our payroll without my notice. Because clearly he has used over 10 minutes marketing Galandi. I take the pleasure. Thank you very much, Juro. I want to thank the President, Uganda Law Society, the most perpendicular Isaac Semakadde Chimeze, Senior Counsel. I also take cognizance of the radical new bar that practices what it preaches. I think we are the most celebrated entity in this country that has embraced digital transformation. And we are the most active. And we need to give flowers to the council for that. And therefore, it's no surprise that the conversation on are we ready for the fully paperless transition in our courts starts here. I'm simply Galandi Tony Kire. I would not want to have that long conversation. Ladies and gentlemen, NN has rendered me useless. So I'm wondering whether I should just thank him and we close this. So my conversation, for avoidance of repetition, we rotate among just a few observations from my experiences and from where I sit. NN has given us a practical example of actually what's happening in real practice. But before I go that lane, it will be very un-Christian of me if I do not appreciate the judiciary for the baby steps that have been taken. We must also appreciate, as a matter of fact, that filing is a little bit easier today than it was a few years ago, because now the ever busy vice chairperson, Asiimwe, in the comfort of his chair, he can be able to file a suit. Of course, to the disadvantage of Juro, who wants to show his client because he wants to manually go. Today, you realize that because of this paperless system, a prisoner in Luzira is able to evade the scourge in that gray bus to come to court for a mention. That can now be done online by video conferencing. So we must give credit to the judiciary for that. Today as we speak, I think the rollout is almost to between 45 to 50 courts in the country. And we must give credit for that. We are able to do the payments online. We are able to track our cases online. But that notwithstanding, I think it is our duty as advocates to also have this question which has been structured so well. Are we ready? In my opinion, we decided to take on this beautiful virgin girl who was underage. But we can't reverse. The virginity is already broken. So 16, not yet 18, we're already there. So the question should be, how do we work with where we are to ensure that a nanny's grandmother in Adjumani is able to have a fair hearing as envisaged in Article 28, the same way Rhoda in Kampala enjoys justice. Or otherwise we risk serving the already advantaged to the disadvantage of the already disadvantaged. You cannot have this conversation of a fully paperless when you know for a fact that the rollout as we speak is at 20%. You can't say we are ready when for a fact you know that a number of over 80% of these courts are not connected to internet. And then you have not provided for the alternative. You cannot have this conversation and say we are ready in a country which has 40 different languages, when you have not gone an extra mile to engage people who are doing language models so that there is transcription, that when we are having this conversation in the courts of law in English, somebody in Madi, somebody in Butaleja, we are getting the same kind of transcription because we have language models that are doing the translation. And this is basic technology. You do not need rocket science, I promise you. It's because we have embraced the white man syndrome. I wonder, and I had a conversation with a high-profile judicial officer not long ago, and I said, as we go paperless, first of all, you will realize the service provider for the system that is being run by our courts is LexisNexis. Now, LexisNexis is a European firm. So what's happening is that while as LexisNexis is allowing you to have the data on your server, LexisNexis controls the source code back end. A source code in basic language is the mother software. It doesn't give it out. But these are basic innovations, I can tell you. So what is the risk? The risk is a white man out there who controls the source code of our system, okay? Controls ideally the data of Anthony Asiimwe. And to me, the question then would be, are we ready to go fully paperless? I would think those are some of the things we need to look at from the cybersecurity point of view, because you're having all these. And I would implore that why don't our court systems, our judiciary, give opportunity to local innovators to some of these things? That is for the judiciary, because we leave a loophole, and that feeds into the question, are we ready to go fully paperless? My other concern is the legislation part of it. They will tell you that we are having practice guidelines for the ECMIS. But a practice guideline is not law. A practice guideline is policy. What happens tomorrow when the ever ambitious friend of mine called Gravedigger, or my incarcerated friend Mabirizi, challenges these practice guidelines and saying they're in contradiction of Article 28(1), because there is no equal justice. The court is in a better position to ensure that whatever they are doing is embedded in a legislative piece. This is what our friends and our colleagues in Kenya have done. They have gazetted. This is what people in Rwanda have done. They have embedded this into a law. You do not want to have something like this hanging simply because the Chief Justice, in the comfort of his bedroom, wrote these guidelines. Ladies and gentlemen, there is need to ensure we invest in encryption, audit access controls, and dedicated response protocols if we are going fully paperless. Without doubt, lawyers will tell you that sometimes these response protocols come days after. So the system is sending you summons days after. So I think all that needs to be looked at it from a deeper perspective before we say we need to go fully paperless. My colleague has talked about the digital divide. You know, we are like bathing a child and putting in the sand. And I'll tell you why. You can't be increasing import tax on phones below 350,000 shillings, which a person deep in the village can afford. Yeah? But at the same time, you are saying you're going paperless. It's a contradiction. Ladies and gentlemen, I would have wanted to speak up tomorrow, but unfortunately I can't, because hungry men are angry men. I've seen the way Juru is looking at me. Clearly, he's not impressed. But that notwithstanding, I would want to summarize in 2 minutes what needs to be done. Number one, in my opinion, we need to close the regulatory divide, have this embedded into law. Number two, we need to address the infrastructure and connectivity constraints so that at a national level there is this push. And then I would also want to talk about cybersecurity and data protection. There is need to ensure that we use locally trained systems. There is no rocket science in what LexisNexis is providing to our courts. I can promise you, from a tech perspective, from an innovator's perspective. But do you know the risk we run? The risk we run is that a foreign entity is running our data. Because he who controls the source code controls the system. Be deceived not. We'll tell you, no, we have your data on your server, we don't have passwords to your system, but who has the source code? So for me, that is really very, very key. And what are the risks? The other risks is if we don't put these security safeguards, they are what you call as deep fakes. Deep fakes is that you can actually have my friend the toilet digger's picture is somebody who is exactly resembling my friend the toilet digger. Exactly same facials that you can't even differentiate, and is the one actually who is a witness on your video conferencing. Those are risks. So in my honest opinion, I believe number one, we should trust our local personnel. Number two, we should train these things on our local data. Number three, we should be able to ensure we close the gap, the literacy gap. Number four, we should lock this into an enabling law. Ladies and gentlemen, thank you very much for listening to me, and we look forward to inviting you for today's Legal Tech Dialogues. We'll be hosting Mr. Chagara Emmanuel, CEO Milima Security and Cyber Academy. We actually want to have this conversation deeper, where we are talking about courts, council, and cybersecurity, expanding the digital frontier, so that we look at things like how are you protecting your data, because your API or your system is now interfacing with the judiciary system, but then you have sensitive data in there of jurors' nudes, which he has kept you to given you as a lawyer to keep to manage his divorce process. But then that, the question is the system watertight. Can't it find a way where the system is going to affect my data? So those are cybersecurity issues that need to be addressed. I beg to submit. Thank you very, very much, Jirua. Let me wish you a good afternoon. Thank you.
Mr. Convener, however, thank you so much, Mr. Convener. He is our inaugural TechFest chairperson who brought the Uganda Law Society's one of the 4Ds digital transformation objective to light beyond we could speak for ourselves. It spoke for itself. We are very honored to receive you. We also need you to know that your accountant has activated my account with 0.5 million shillings. Thank you so much. I want to imagine you've already communicated. Thank you so much. We also take cognizance of the flowers you've given to the judiciary, which of course the council that is going to be represented here by the next speaker, that's the vice president, has taken note of. We cannot go without saying so. But also, Mr. Convener, when you alluded to a 16-year-old and yet you spoke about the 20% coverage. Mr. Convener, the person behind me was wondering whether that is 16 years or that is 8 years or less than 8, to know whether the offense will be aggravated. But we shall not go so much to know how far the judiciary has gone with that aspect. Of course, we are also taking cognizance of your position, really. After giving flowers to the judiciary, you have also shared your position, and clearly the judiciary or the country of Uganda is not ready, especially if you're speaking about very critical aspects about cybersecurity. You're speaking of language barrier, you're speaking of internet coverage, you're speaking of the service provider being from Europe, which of course is also something that we keep on learning in these sessions. We are learning every now and then. It is for us to criticize and also ask more questions. These are the conversations that the Radical New Bar is setting forth for members and the public to understand. We also want to appreciate that these practices have been legalized in Kenya and Rwanda, which is part of the East Africa community. And the question is as to whether we are ready if we are simply only creating them as guidelines. We have had experiences where the Bay guidelines have been used to speak beyond the Constitution by judicial officers, and we ask questions as to whether it is the right thing to do. And of course, in summary, you have addressed quite a number of things, including what to do. What can we do in order not to go back, because we have already crossed the line, and yes, the child is underage, but we are wondering whether it is aggravated or we are at 16 to 17 years, where you can't make a difference. 17.5 years and the person looks a little older. But the question really is for us to ponder, and the Uganda Law Society, which of course is always ever available given the flowers you've given them, or the Uganda Law Society as a celebrated organization that has easily embraced digital transformation. To that effect, Mr. Convener, we are very honored and thankful for your service. Thank you so much. A round of applause for the convener. Please, let's give him a hand clap. And we pray that you will continue to be blessed as you interact with the Uganda Law Society. The High Command always gives you flowers, and the High Command takes cognizance of your efforts. May the Lord bless you. Thank you so much. Ladies and gentlemen, we're coming to the close of this session, and we are going to finally host the Vice President of the Uganda Law Society, who is going to render unto us a statement on the Council position in regard to this particular topic. In other words, the judiciary position of going paperless. As to whether or not we are ready, the judiciary is already going on, whereas for us as the Uganda Law Society, under the leadership of the Radical New Bar, being represented right now by the Vice President, the Acting Secretary, and the Treasurer or the Governor, who was easily walked out but is still around, is going to render unto us their position or our position in order for the public to know where we stand. Ladies and gentlemen, the Vice President of Uganda Law Society, Advocate Anthony Asiimwe.
Thank you very much, Jurua. Very energetic as always. You never run out of steam. The president of the Radical New Bar, Isaac Chimaze Semakade, Senior Counsel, who is definitely following us online, the members of the Governing Council, those who are here physically and those following online, our esteemed panelists who are also members of the bar, Secretariat headed by the CEO, Madame Christina Ori, and the Fourth Estate, members of the press who have been
the most important partners of ours. If you look around the room, our conference facility, and you see the photos we have, it tells you how much we value your work, how much we value your contribution. We do not want to take it for granted. A good afternoon to you all. I bring you greetings from the President and my colleagues. And following the discussions, I almost said the same thing my colleague, my namesake, our chair, Galandi, said about NN's presentation, that he almost said he has nothing useful to add because all has been said. But this is it's the Uganda Law Society's preliminary response to Administrative Circular number 1 of 2026, which was issued by the Chief Justice, which has been talked about. And I want to believe, pursuant to that circular, as of Monday this week, the directive was that those courts that have ICMIS must go paperless completely. And I want to imagine what could be happening there between Monday and today, being a Thursday. But our position is that the Uganda Law Society supports paperless court system, but calls for stronger safeguards and inclusivity. And this is the official position of the bar, the National Bar Association, that the Uganda Law Society welcomes Administrative Circular number 1 of 2026, issued by His Lordship, the Chief Justice, Dr. Flavian Zeija, on the 17th of February 2026, announcing the transition to a paperless court system. This initiative aligns closely with Pillar 4 of the Radical New Bar Governing Council's position, which is digital transformation of our Radical New Bar Vision 2060. You know about our 4 Ds, and the 4th is digital transformation. And this is mainly aimed at championing innovative technology-driven reforms to modernize legal practice, enhance efficiency, reduce case backlogs, and make justice more accessible and transparent for all Ugandans. That is the purpose of this digital transformation agenda. The Uganda Law Society equally welcomes the report launched last week by PM Digital Law Hub, titled Assessing Readiness for Uganda's Transition to a Fully Paperless Judiciary, effective 1st July 2026. We extend special commendation to Advocate Paul Muchibi, the Executive Director of PM Digital Law Hub, and his research team led by Ms. Patience ISJ, for supporting the bar in fulfilling its statutory mandate. They conceptualized and executed a survey testing the nation's readiness to achieve the aims of Administrative Circular number 1 of 2026. As the National Bar Association, we are sincerely grateful to all advocates, lawyers, judicial officers, court staff, litigants, and other stakeholders who participated in the online survey and generously shared their experiences, concerns, and recommendations. Now, the Uganda Law Society deliberately withheld comment on Administrative Circular number 1 of 2026. Even when it was shared, we received calls from members of the press, from the public, from, members of the bar, calling for our position, seeking our position on this administrative circular, but we deliberately withheld these comments. We chose not to do that, specifically to avoid giving the impression that we had reached conclusions before hearing out the stakeholders. Now, this report by PM Digital Hub now provides an objective baseline as we move under Section 3E of the ULS Act, which mandates us to assist government and the courts in transitioning to a paperless judiciary by 1st July 2026. And this is our preliminary response to that circular, also considering that we take cognizance of the report and the presentations. I was part of the panelists during the presentation of that report, and I gave partly what we considered or what our position was as the bar, though not in a conclusive manner, but it was a reflection of the thoughts of the members of the bar. Now, our preliminary response is as follows. The Uganda Law Society has previously voiced constructive criticisms regarding the judiciary's slow pace of digital migration in light of its substantial budget allocations over the years for ICT infrastructure and systems like the Electronic Case Management Information System, the ICMI system we are talking about. Now, while progress has been made since its launch in 2022, and phased expansions, including full paperless transitions in court like the Court of Appeal by late 2025, the bar notes that Uganda unacceptably lags behind regional peers such as Rwanda, Kenya, and Tanzania in delivering a comprehensive, inclusive digital justice ecosystem despite the investments made by taxpayers. Now, in the spirit of partnership and advocacy for people-centered judiciary, the ULS primarily takes issue with paragraph 2E of the circular, which states, and I'll quote, that under this regime, judicial officers shall conduct proceedings, manage cases, and deliver decisions using the Electronic Court Case Management Information System, ICMIS. As the Radical New Bar, we do commend the bold commitment to ICMIS as the core platform, but highlight critical gaps that must be addressed to safeguard constitutional rights, ensure equitable access, and prevent unintended exclusion of any erosion of the rule of law. Our concerns are drawn from stakeholder experiences, comparative e-justice systems, and best practices for the time being as follows. Number one is lack of explicit subjection to constitutional safeguards. Now, this circular does not affirm that the paperless regime remains fully subject to Article 28(1) of the Constitution, which guarantees a fair, speedy, and public hearing before an independent and impartial court. I think the speakers before me spoke to this, and it is our concern, the fact that it is not pointed out explicitly, because it's one very important core, the important safeguard, constitutional safeguard of the right to a fair hearing. And that is our concern, because this circular is silent on that. Secondly, insufficient guarantees for open justice, media freedom, and public access. Now, there is no clear provision upholding the open justice principle and rights under Article 28(1), which includes public hearings, 29(1), which provides for freedom of expression, including press freedom, 38, which provides for public participation in government, and 41, access to information, as well as Article 126, which provides that judicial power is derived from the people and the exercise and should be exercised in the public interest. Now, this means that public and media access to court records, proceedings, and decisions, unless sealed by reasoned court order after the justification hearing, must be explicitly protected to prevent a shift to opaque electronic justice. The members of the press here, on a daily basis, I meet you in courts covering some of these cases. You follow the proceedings, and you're able to give an account, especially cases of public interest, where the public is interested in knowing. And with this kind of circular, where everything has to be done online, Galandi was talking about how I can sit in my, the comfort of my office. I send the pleadings, I send the submissions, my fellow colleague does the same, and the judicial officer will also deliver the ruling online. I'll not even need to go to court. Now, have considerations been made for this right, where the members of the press should be allowed to cover the proceedings and follow? If you cannot access that system because you're not, linked to the case, if you cannot even get to know what I've filed in court, yet this right is enshrined in the Constitution. It's a constitutional provision and right which must be respected. And it is our concern that there's insufficient guarantee for open justice, media freedom, and public access to these proceedings, which is equally unconstitutional. Thirdly, there is risk to judicial impartiality and flexibility for complex or high-stakes cases. Now, purely electronic handling may hollow out impartiality and human elements in sensitive matters. For example, constitutional petitions, land disputes, or cases involving vulnerable parties. No recognition exists that some proceedings require hybrid or in-person options for fairness. It is left to the arbitrary discretion of the courts, which portends conflict between the bench and the bar, and the bench and the public, leading to inconsistent practice. This is also the concern of the bar. This is one area that has not been taken care of. It's a big risk to judicial impartiality. Number 4, there is no robust contingency for technical failures. Now, the circular unacceptably omits protocols for electricity outages, internet disruptions, system glitches, cyber threats, or hardware failures, which are common in Uganda's context and were seen in other jurisdictions early e-court ruleouts. And then Ambrose has, elaborated on this. Mr. Galandi here has spoken to this. And these are experiences shared, the experiences we've gotten from other users. And when you had Jurua talk about my experience, I shared, it's a similar experience with what has been done so far with the ICMI system so far. But the fact that we see this circular with no robust contingency for technical failures is worrying. And it might be dangerous for access to justice. Number 5 is the exclusion of marginalized and poor litigants. Now, vulnerable groups, especially the rural poor, the elderly, low income, those without devices, those without internet or digital literacy at all, face barriers without provisions for assisted access, digital training, legal aid integration, or hybrid filing options. Now, ICMI's rollout follows a top-down urban-centric logic. The pilot in Kampala and well-resourced courts then trickled down to hard-to-reach districts. If you look at the 49 courts that have been rolled out to use ICMIs, none of those courts is in the deep rural. They are all in urban centers. And that is why the test has been done. That may prove the software works, but it fails the justice test. The worst day is missing files, high pretrial remand, and absenteeism are not in Nakawa. They're in Mbale, they're in Barara, they're in Masaka, they're in Lira, they're in Kabong, and other courts which are off the grid. By starting at the center, the judiciary has maximized optics, while the litigants who need reform must wait longest. The common person, the litigant in Kabong, in Kaberamaido, has to wait. The radical equity first alternative is a last mile first or anti-clockwise strategy. Begin rollout where the justice gap is widest, not where it is actually narrow, like it has been done. If ICMIS functions in courts with poor connectivity, low digital literacy, and no resident lawyers, it will function anywhere, and that's where it should have started from. I don't know how many lawyers practice in the region where my, NN comes from, but I can assure you the numbers there are so limited, and there are areas where there's not even a single lawyer. But these are the areas, these are regions where litigants equally have problems. These are litigants who are not educated. You heard Galandi talk about the issue of phones and the taxation. Even before we get there are people who cannot even afford a smartphone, not even airtime. And there are areas that do not have internet at all. But these are people who come to court to seek justice, who have justice needs, and they must go to court. So we're saying build for the periphery, scale to the center. If it works in Chiriandongo, it will work in Kampala. That approach closes the digital divide instead of reinforcing it, and signals that no citizen is too remote for the law. Number 6 is failure to address persistent judicial misconduct issues. The 4-year pilot phase shows that ICMIS does not, by itself, resolve judicial arrogance, lack of compassion, delays, or exclusionary tendencies. It remains a tool whose impact depends entirely on the mindset and integrity of its users. The circular issued offers no safeguards against judicial idiosyncrasy and discretion. The most embarrassing example has been talked about by my colleague here, NN, the Gaba Mobile Court's refusal to acknowledge and fix for hearing a case filed by the Uganda Law Society. This is a case we filed on ICMIS, but because the judicial officer has discretion to admit or not admit documents on ICMIS, to fix or not to fix, it exposed a deeper rot, a deeper problem with this system. Our complaints to the principal judge, Chief Justice, and the Chief Inspector of Courts were in vain. We complained about this in writing. It was never attended to. It's paperless. Incidentally, these complaints had to be taken in hard copy, not on ICMIS. But you're saying we should go paperless. Now that failure alone signals to judicial officers that abusing ICMIS to disfavor or avoid sensitive filings carries no consequence. And this is what we've been seeing. This is what will continue to happen. They'll only fix matters selectively, not those they're uncomfortable with. And because it is on the system, you can't do much. I had an end talk about, bail applications. Just 2 weeks ago, I have a colleague with whom we teach criminal proceedings at the Law Development Center. He appeared at Uganda Road Court to apply for bail for a client. And some of our students were actually in court. And the magistrate tells him that we cannot proceed with this bail application because I cannot see your documents. And the man is saying, but we uploaded everything on ICMIS. The AC letters, the national IDs, we uploaded them on ICMIS. And the judicial officer says, I cannot see them. I'm adjourning the matter and remanding your client further. It was a bit embarrassing. Not a bit, very embarrassing. Not just for the person of his stature, but the message you're sending to these students of law. This is someone who is almost head of the subject. These are the embarrassing aspects we've witnessed. And the fact that there are no consequences for these people who abuse judicial power using the system is worrying. Magistrates abuse the system by arbitrarily directing court users to file written applications or submissions in routine matters previously handled orally. This imposes unnecessary costs and delays and turns ICMIS into an instrument of judicial tyranny. Another example, we're representing Rnblive and raised an issue that the judicial officer should recuse herself. It's a matter where she could have listened to us and offered a ruling, given a ruling there and then. But she says, no, you file your submissions online. I'll deliver my ruling. Which we actually said, no, we cannot do that. But these are the dangers we are seeing. And this has not been addressed by this circular. The number 7 is limited integration with other national databases. The circular makes no mention whatsoever of interoperability with systems like those of the National Identification and Registration Authority, Uganda Registration Services Bureau, Law Council, police, prisons, or land registries for seamless data flow. Lack of interoperability fragments justice delivery, forces manual re-entry of data, and creates bottlenecks that delay bail, case tracking, and enforcement of orders. You can imagine if you're handling or representing a client in an application for letters of administration, the court has to verify from NIRA, actually from the Administrator General's office, whether the certificate of no objection you presented is authentic, whether the national IDs, just like in bail applications, are authentic. There are institutions that have these documents. But the fact that there's no integration, that means you have to again go and seek physical verification. If you're entering the name of an administrator on a certificate of title at the land registry, the Register of Titles seeks verification from court whether the letters of administration, whether the grant is genuine, is authentic. Now, the fact that this system has not integrated with this other system means you're bringing back, you're not solving these bottlenecks because someone has to write a letter, the registrar has to write a letter to court. Then the court registrar has to write back and confirm that it is true, it is not true. What are we solving here? Similarly, why should the state attorney say that they've not yet verified national IDs, which have been uploaded on the system? Yet there's a system. There is a National Identification and Registration Authority, which equally has a system where you can verify on the spot. Now, until this is implemented, someone will remain unexecuted while pretrial detention becomes normalized. Accused persons will continue to overstay. Victims will wait longer for orders, and absconders will go undetected. This omission violates the principle of efficiency under Article 126(2)(b) of the Constitution and defeats ICMIS's own objective of a paperless, integrated justice system. Number 8 is the non-involvement of the bar and other stakeholders. This is our other concern. The proclamation of the circular was unilateral, without prior consultation with the ULS and other stakeholders, as confirmed by PM Digital Law Hub reports. And we mentioned this. I did say that during the launch of the report, that it's very important for the judiciary. It would have been very important to consult or involve the stakeholders before even this circular was issued, so that we equally assess the readiness and address or advise on addressing some of these challenges before we get there. And the question that we've been asked by the media, by other colleagues, and even if you look at that, if you look at that report, the question was, the report launched by PM, the question was, are we ready for a paperless judiciary? Number 9 is opaque case allocation. And this speaks to random, transparent, automated allocation through algorithm with audit trails is needed to end perceptions of bias and judge shopping. There is no clear justification for retaining the pre-ICMI system of case allocation, which continues to erode public trust and delay access to justice. This is another gap that is easily utilized and taken advantage of in abuse of process. And number 10, and the last concern, is absence of interim emergency protocols. The pre-ICMIS era was impermissibly negligent on urgent matters. Courts normalized delay by failing to provide mechanisms for night applications, ex parte injunctions, and emergency bail. That wasn't efficiency. ICMIS should have come to resolve this. You would move months and months to fix an urgent matter. And most of them, by the time they come up, they've been overtaken by events. That's not efficiency. That's not what justice is. The result was a culture where waiting was treated as due process. And we had accepted to live with that, unfortunately. ICMIS must not inherit that laxity. It must reverse it with automated safeguards and 24-hour access. That would be efficiency. Additional self-evident shortfalls from comparable systems include weak data privacy, cybersecurity standards, inadequate training for judicial officers, staff, litigants, and no phased monitoring and evaluation framework. These have been spoken to by the earlier speakers. Now, the Uganda Law Society is providing the best-in-class solutions and recommendations. Some of them have been given by my colleagues here, but I'll specifically speak to the recommendations we are giving. We are calling them the best-in-class solutions and recommendations. And for an inclusive, rights-respecting paperless regime, the Radical New Bar recommends issuing a revised circular or supplementary guidelines. What we are saying is that after pointing out the challenges with the circular issued by the Chief Justice, the inefficiencies and the challenges observed there, we do recommend that the Chief Justice issues a revised circular or supplementary guidelines if this system, the paperless system, is to work or is to achieve the intended goal. Number 1, explicitly subordinating the ICMIS regime to Articles 28, 29, 38, 41, and 126 of the Constitution with mandatory public access portals, probably a read-only version of documents in non-sensitive cases, and live streaming virtual viewing options as it is being done in Kenyan courts. This will even enable members of the public to participate or follow the proceedings. If someone can open an only read document, they don't have rights to change or adjust anything. We'll at least ensure that these safeguards are protected. They are constitutional safeguards. Number 2, mandating hybrid flexibility. To ensure transparency and accountability, courts must retain discretion to require in-person hearings for complex or human rights sensitive matters and must record reasons whenever virtual proceedings are displaced. Number 3, establishing contingency protocols. Court must require offline filing backups, solar or generator power backups, which are 24/7 IT support, and automatic adjournments or extensions for verifiable technology failures. And this is drawn from the South African hybrid model during load shedding. I think Enen spoke to this, to the options, being a digital person. And this is also an important recommendation we are making. Number 4, promoting digital inclusion. The revised circular, which you are calling for, must commit the judiciary to partner with the ULS, NGOs, and private sector to provide free public access kiosks in courts, digital literacy clinics, subsidized data bundles for low-income litigants, and mandatory pro bono digital assistance, drawing on the experience of Justice Centers Uganda. E-Justice Citizen Support Center models have proven effective in other jurisdictions. These ICMIS kiosks we're talking about must not be monopolized. Kiosk operators should be licensed in the same manner as court bailiffs. They are the members of the public who will be able to choose. As long as they are licensed people. We are looking at closing the gap. And for purposes of inclusivity. Number 5, enhancing transparency and accountability. The judiciary should implement automated randomized case allocation with public audit logs, integrate mandatory judicial training on compassion and ethics in digital context, emphasizing the principles initiated in the POPs in Clinical Magnifica Humanitas, and link ICMIS to national databases to enable real-time data exchange. Number 6, ensuring stakeholder collaboration. A joint judiciary ULS digital transition working group should be constituted to provide ongoing input, monitor implementation, and recommend rule amendments, including interim emergency protocols. It cannot work like a robot, because as and at any stage we recognize or we identify a challenge, a problem, it should be resolved. A solution should be resolved, should be found there and then and implemented. Number 7, and lastly, adopting cybersecurity and privacy standards, which has also been talked about by the experts. ICMIS should be aligned with international benchmarks, including GDPR-inspired data protection standards, and subjected to regular independent audits. And this is also for purposes of ensuring transparency. Now, the Uganda Law Society stands ready to collaborate with the judiciary to refine and implement these enhancements, ensuring the paperless transition truly serves the people, upholds constitutional values, and positions Uganda as a regional leader in inclusive digital justice. We urge prompt dialogue to address these matters constructively. And that is our position as the National Bar Association. Thank you all for listening to me. And as I emphasize, the title of our position is that ULS supports paperless court system, but calls for stronger safeguards and inclusivity. Thank you for listening to me.
Thank you so much, the most perpendicular Vice President of the Uganda Law Society, Advocate Anthony Asiimwe, for doing justice to the circular that the judiciary released. We have come to the tail end of the function today. A lot has been said. I'm sure that statement is going to be shared widely on the different social media platforms, and we shall easily get access to the same, as has been the habit by the Uganda Law Society. We are as transparent as it comes, and we would like to pay cognizance to the Vice President in representation of the President and the Governing Council, Isaac K. Semaka, the Senior Counsel, who of course we're very sure is following us and watching us. Thank you so much for your guidance, your leadership, the blessing that you come with, and for continually being relentless and restless towards the ensuring of rule of law, especially as mandated in our Act, the Uganda Law Society Act, Section 3, C, D, and E. We continue to identify with what the Vice President has said. I don't have anything useful to add after that, other than invite the Acting Secretary General to help us close this function and see to it that we can have a blessed day beyond this. It has been an honor to be before you. I was really excited about what has happened today. We want to give credit to all those individuals that have been with us from the time we started physically and those online. The topics were really, really wild, and we know that at least we have gained one or two things, and we pray that the Lord will bless you as you partake of the closing remarks and get back to your endeavors as human beings. We pray all this and knowing that we are in one accord. We say this for God and my country. Ladies and gentlemen, the Acting Secretary General of Uganda Law Society, Advocate Sally Babu.
Thank you once again. Thank you once again, Robert. And I once again wish to thank all the members of the Uganda Law Society, members of the Uganda Law Society Secretariat, those here physically and following online. And then in a special way, I wish to thank the panelists of the day. That is Dr. Lutoti Stephen, Mr. Frank Onyango, Mr. Patrick Odongo, and Dr. Ekwaro Obuku, who presented earlier and have since left. And I also wish to thank Mr. Frank Asiimwe as well. And then Advocate Tony Galandi Chire, Advocate Ambrose Enen, and the Vice President of the Uganda Law Society, who have spared time amidst their busy schedules to come here today and present as panelists. And I also wish to thank the team under the Rule of Law Department headed by Advocate Afra Apio, and also Robert Jurua, who likes being introduced by all his three names. Yes, as Robert Benon Jurua. Thank you for the great work as well as your team. And then also, without forgetting, the topics of today have been basically a fully paperless judiciary and asking whether we are ready. The position of the bar is we do not in any way oppose a paperless judiciary, but however the same should be achieved in line with Article 28, which talks about a fair trial, so that all members or all participants in the process of litigation are taken care of or are considered, because as it stands today, we are not even close to 10 or 20% in achieving the same. And if it is really imposed on the public, then it would mean that many are going to be left out of the process of litigation and fair hearing. And also, in a special way, I would also wish to thank the Radical Nuba Governing Council President Isaac Semaka Chimaze for tirelessly ensuring that he steers the Radical Nuba Governing Council and the Uganda Law Society on and advising as well as guiding on all aspects that fall within our mandate of Section 3 subsection D of the Uganda Law Society Act. By that, I wish to close the 18th session of the Radical New Bar Governing Council series. And with that, I also wish to thank the students who are here and call upon members to follow this series as and when we communicate in large numbers as they have done today. Thank you all. Yes, you could kindly come for a photo moment.